Good morning, everybody. Happy Super Friday. Welcome to TCF Live. I am Dan Soul, and I will guide you on a 3-hour journey through Courtlandia, starting today in Kent County, Michigan. This is Judge Rossi.
And this matter comes before the court today on an allegation that Mr. Delaney violated my order of probation. So I'll let Mr. Holtrop from MDOC lead us off. You're muted, Mr. Holtrop.
Sorry about that. Cody Holstrop for the Michigan Department of Corrections. The matter before the court today is the people of the state of Michigan versus Patrick Delaney, docket number 25-03763-FH, petition for violation of probation. The defendant was placed on probation by this court on September 4th, 2025 for a period of 18 months for the offense of controlled substance possession of methamphetamine. Today, he appears on violation for terms 03 and 2 counts of 2.4. As of today, he has a total jail credit of 8 days.
Thank you. And Mr. Goings, would you put your appearance on the record, please?
Certainly, Your Honor. Thank you. Nicholas Goings on behalf of Mr. Delaney.
Thank you. And sir, you're Mr. Delaney?
Say what?
You are Mr. Delaney?
Yes, I am.
Would you please raise your right hand? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes, I do.
And Mr. Delaney, you understand the maximum penalty I could impose for this probation violation would be up to 10 years in the Michigan Department of Corrections based on an underlying charge of possession of meth.
Yes.
Okay. And you've had the opportunity to review the allegations in the probation violation report with your attorney, Mr. Goings? Is that correct, Mr. Delaney? Mr. Goings
yes.
discussed the violation report. And,
yes.
I'm sure Mr. Goings has also told you if you disagree with what it says in the report that you're entitled to a hearing. I'd conduct that in person in my courtroom. During that hearing, you'd be entitled to be represented by an attorney, which I would appoint if you can't afford one. And your attorney, be it Mr. Goings or another attorney, could cross-examine Mr. Holtrop and any other witnesses the prosecutor might put on the stand, as well as use the subpoena power to bring in witnesses who would tell your side of the story. You understand you have the right to that hearing.
Yes.
And Mr. Goings, what does Mr. Delaney wish to do with the alleged violation at this time?
Your Honor, it's my understanding, if it's perfectly okay with the MDOC and Agent Holtrop, that Mr. Delaney would plead guilty to absconding probation and non-technical violation that he failed to report on November 20th of 2025 and had been absconding since. If that's acceptable, I'd ask that the remaining 2 counts be dismissed. We can proceed with sentence after.
Very good. And that's acceptable to you, Mr. Holtrop?
Yes, Your Honor.
All right. And Mr. Delaney, has anyone offered you anything in exchange for a plea to guilty of violating probation at this time?
No, sir.
Has anyone threatened you?
No.
So your decision to plead guilty today is your own choice?
Yes.
And specifically what you're pleading guilty to today is a failure to report to probation in violation of term 3 of the order. In that, after about November 20th of 2025, you didn't report to the probation department.
Correct, sir.
All right. We accept the guilty plea, finding it voluntary and supported by an accurate factual basis. We'll move directly to the sentencing portion. Mr. Holtrop, anything to add from Department of Corrections?
No, Your Honor.
Mr. Goings, anything you'd like to say by way of elocution?
Briefly, Your Honor, it's my understanding from Mr. Delaney that during this time of absconsion, obviously that's not condoned by the court, but he did check himself into, and I think he said he completed a 45-day rehab stint, drug rehab stint in Ingham County. He does have a medical situation. I'll let him explain that to the court in further detail, but got a medical emergency back in December of 2025 that kind of took him away from other matters. But I'd ask the court to consider that he's been sitting since the 16th. He's taken care of all his matters. He's got about 8 days of credit, and I'd ask the court to take that in consideration when imposing a sentence here.
All right, thank you. And Mr. Delaney, what would you like to say before I impose the sentence?
I did voluntarily bring myself into rehab to stay clean, and that was pretty much to keep me alive. And after that time, yeah, before I went to rehab, my guardians were in touch with the probation officer, about turning myself in, and they thought it was better that I go to rehab than go to jail. But I did go to rehab to better my life, and not only that, but I also do that to see my son, who I get to see on a voluntarily supervised visit through journeys and stuff. And yeah, I did have a massive accident back in December. I had a heart attack, 4 strokes, 4 watershed strokes, and aortic dissection, which kind of took me out the loop for a minute, which is why I went to rehab to get clean.
You're lucky to be alive after that, Mr. Delaney.
Yeah, I know that, which is why, I went to rehab to make sure to stay alive. But yeah, I won't waste any more of your time.
All right. Well, thank you, Mr. Delaney. I appreciate your honesty, and what's been going on here with you. And I'm sure, after that, nearly near-death experience, sounds like, you had a moment where you said, hey, the way I'm living isn't going to result in. I think it's like the old timers in Alcoholics Anonymous say, you get sober or die. Eventually you got to face that choice. And sounds like you faced up to it and you did the right thing. You got yourself into a rehab program that at least got you, the tools to stay clean. I'm sure they told you at rehab. And, I'm going to tell you today, none of that stuff is a one and done scenario. I wish I could tell you, oh, well, one rehab program or magical program, it's a silver bullet and, it solves all the addiction issues and you go forth and you don't have to worry about that anymore. Well, of course, it's not the case. In fact, the hardest time sometimes when you get out of a program like that, you're back in the community, you got to face all those triggers and issues that came up for you before and try to stay sober with all that going on. I think the recommendation here for 180 days is a fair one. What I'm going to add to that, Mr. Delaney, is I'm sentencing you, as I said, that single count of methamphetamine. Guidelines are 0 to 11 months. So the sentence is within the guidelines, and it will be the sentence of the court that you serve 180 days in the Kent County Jail with 8 days credit. And I'll grant you an early discharge if you successfully complete the sober living unit there at the jail. Now, I know you got pending charges and stuff coming down, and I don't know how that's going to impact that.
No, I don't.
Oh, you don't have anything coming down from the
Uh-uh.
I thought there was something coming out of that Granville incident, but that you got it resolved? Good. Well, if you got that resolved, then, basically, what you're probably going to find is the sober living unit. It's taught by the people from Arbor Circle, the same people that you would go to if you took the class out in the community at their Arbor Circle facility. They come to the jail. They give you that intensive outpatient treatment program class in a, faster than usual format right there in the jail. Some of it may be a repeat of what you did before, but, I've been to a bunch of seminars and stuff on addiction and relapse, and they said the average person, has to go through programs like that, 5 to 7 times before they something clicks and they decide, hey, I'm going to put that stuff to work in my life when I get out of that program and stay sober. So I'm hoping this is that for you, Mr. Delaney, because otherwise, with all that health stuff going on, relapse in some respects could be, the equivalent of a death sentence for you. It shouldn't be that for anyone. You mentioned it, you got a son to live for, people who care about you. So, I'd encourage you, put that stuff to work when you get in the community. If that means going to NA or whatever it takes, pull the stops out to stay sober and make those changes this time around. So, I'll revoke the probation at this time. Any fines and costs that were assessed will remain in place at this time. And I'll advise you it's a final judgment of the court, so you have the right to appeal. Your appeal is to the Michigan, by leave to the Michigan Court of Appeals. And I'll appoint a lawyer to represent you if you wish to appeal, but you can't afford an attorney. And you can get a green form at the JLS to ask me to appoint that attorney at no charge. If you wish to do that, you need to get that green form back to me within the next 42 days, or I'd have to deny the request. Wish you the best of luck at, like you say, I hope you get through sober living, get you out of there a little earlier than otherwise. And, most thing I wish you is that you manage to maintain that sobriety out in the community. Good luck, Mr. Delaney.
Thank you.
Good morning once again, everybody. It is TCF Live on a Super Friday. Good to have you all here with us today. Barbara, thank you for the $5. Says happy Friday, everybody. Thanks to Dan and all of the Sidebar panel for a wonderful show last night. Well, thank you, Barbara, and I agree. It was a good show. It was fun. Let's, looks like new contestant with Judge Rossi. Let's continue with him.
Okay. Uh-oh. Did you get a prompt, Nick? We are here in the matter of the people of the state of Michigan versus Thomas Parham, case number 25-06502-FH. And this hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on an allegation that Mr. Parham has violated my order of probation. So I'll let Mr. Melton from probation lead us off.
Good morning, Your Honor. This is Dominic Melton on behalf of Kent County Probation. This matter we have here before the court is related to Thomas Parham. Let me see here. Give me, sorry, 1 second. My computer kind of took a freeze on me here. Sorry. Yes, Mr. Parham, he was placed on probation by the court on 1/8/26 for the offense of police obstruction of justice for one count, and then another one for operating intoxicated while occupying someone in a vehicle under 16 years of age. Mr. Parham is brought here today on new violations under term 1. On or about 7/19/26, Mr. Parham drove over the speed limit while operating a vehicle. Term 1 again, also related to the 7/19/26, Mr. Parham operated a vehicle while license was suspended. And term 2.0, which is not to use alcohol. On or about 7/20/26, Mr. Parham consumed alcohol. Also additional violation is term 9.37. Must participate in the Department of Corrections alcohol monitoring program, which on 7/20, Mr. Perm obstructed scram monitoring, was obstructed in the situation where, meaning a tampering alert, Your Honor. And then the additional, another violation on 9.37, which coincides with term 1 of consuming alcohol. Mr. Perm was currently out on bond for multiple other violations which he has pending charges that's going on right now, Your Honor. It says jail credit wise he has 9 days, but that is inaccurate because the days since Monday should be added in additional to that, which is 4 days. So that will put him at 13 days, Your Honor.
Very good. Thank you, Agent Melton. And counsel, will you place your appearance on the record, please?
Excuse me, Paul McDonough on behalf of Mr. Parham, Your Honor.
Very good. Thank you, Mr. McDonough. And Mr. Parham, would you please raise your right hand? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes, I do.
Very good. Mr. Parham, you understand the maximum penalty I could impose on the underlying charge here would be 2 years in the Department of Corrections.
I understand, Your Honor.
Okay, and that's for that resisting obstructing charge you're on probation for at this time. And you've also had an opportunity to go over the probation violation report with Mr. McDonough?
I have not today, Your Honor.
Okay, well, you haven't had a chance to have a breakout room or have discussion with him about the contents of that report?
No, I have not, Your Honor, not today.
Have you had an opportunity to see the report? Have you had an opportunity to read or review it?
I have not, Your Honor.
Okay, do you wish to have some additional time to do that, or do you feel like you understand what's in the report based on what Agent Melton said?
I have a good understanding of it, Your Honor. I just, I have some things I would like to talk to Paul about. Yeah, I'm on an alcohol dependency shot, so I can't drink alcohol, but there's some things I would like to bring up to Paul about, if I could.
Yeah, certainly. We can place you in a breakout room with Mr. McDonough at this
Okay,
time.
it shouldn't be long, Your Honor.
Thank you.
Excuse me, CL? No, they're gonna put me in a room. Thank you.
There we go. My mic didn't want to unmute properly. Anyways, I guess that's it for Judge Rossi for the moment. Good morning once again, everybody. It is TCF Live on a Super Friday. Good to have you all here. Let's stay in Michigan, but let's go to Judge Elmore. Say good morning to him.
All right, we are on the record now today at the 28th Circuit Court here in Wexford County, and we're taking up the case that is People of the State of Michigan versus Harold Arthur Bennell. File number is 25-14154-FC. Appearances from counsel, please.
Nate Carnes on behalf of the people.
Thank you, Your Honor. Patrick Cherry on behalf of Mr. Bennell.
Bennell joins us today via Zoom from prison facility run by the Michigan Department of Corrections. Mr. Bennell, are you able to see and hear the court, sir?
Yes, I am.
Thank you. Also here in the courtroom today is Mr. Kevin Steffel. He's the agent from the Michigan Department of Corrections who prepared the pre-sentence investigation report. This case was sentenced on February 23rd of this year, and that was for a charge of criminal sexual conduct in the 3rd degree upon a person between the ages of 13 and less than 16. right. Now, I am looking, what are we here for? I know it's a review of the sentence.
If I may, Your Honor,
Yeah, go ahead.
on the judgment of sentence under paragraph 3, during the sentencing, the court did not check the box for sex offender registration as required and has been completed.
All right. 1 second. So all I need to do is make note that we're checking that box as it's required. I don't think I do recall receiving a letter 2 weeks ago. All right. Mr. Bunnell, it's an important, but I'm just going to tell you it's a formality. The court needed to, and I just failed to check, or we failed to check that box on the form. Anything else I need to hear from the defense on behalf of the defense? Jerry?
I don't disagree that the box should be checked, but there's no waiver of any other sentencing issues that Mr. Brunel may be pursuing on appeal. I don't know that he is, but I'm making a record of that.
Yeah, no problem. And I do see that there's some appellate. There was a request for appointment of counsel back on March 20th of this year, which was received timely. And I see that there have been some requests for transcripts. So it's clear that this is being reviewed for an appeal. 1 second. Yeah. All right. So anything else on behalf of the people, Mr. Anything on behalf of the people?
No, Your Honor.
All right. All right. Well, this court will simply make that modification and reissue judgment of sentence. Does anybody know how many days of credit he has? So I make sure I give the appropriate days of credit. Let's see, he originally had 113 days. And quick look here.
I think the prison would be okay if we just amended to add it from that sentence date, just to add that box 3.
Oh, all right, we can do that. Note that it would be 292 days. I'll leave it up to the clerk to how to fill out the form. All right, Mr. Bunnell, thank you all for your time today. That amended order will be issued here. Thank you all for your time today. We are adjourned.
Thank you, Your Honor.
Alrighty, friends, we might check back later when he racks up another contestant. Slower morning out there in Courtlandia, as it often is on a Friday, but it'll pick up. But in the meantime, let's go back to Judge Rossi. He has started a new stream, so let's see what's going on.
This is Greg Heiler, case number 25-09166-FH. And this hearing is being recorded on Zoom and live streamed on YouTube.
And Mr. Haller is before the court today on an allegation that he violated my order of probation. So I'll let the probation department, Ms. Gutierrez, you may lead us off. Unfortunately, I can't hear you, Ms. Gutierrez. It looks like you successfully unmuted, but Not getting any audio. May need to have to boot you out and have you log back on to fix that. We can do that, and I can proceed and advise Mr. Heiler what's going on at this time while you're doing that. So we'll take care of two things at once. All right, and sir, you're Mr. Greg Heiler. You're going to have to unmute, sir.
Yes, I am, sir.
Could you please raise your right hand? You solemnly swear or affirm that your testimony today will be the truth and nothing but the truth.
I do, sir.
And Mr. Heiler, you understand the underlying charge here. Carrying a concealed weapon carries a maximum penalty of up to 5 years in the Department of Corrections.
Yes, sir.
Okay. And have you had the opportunity to go over the probation violation report with your attorney, Mr. Goings?
Yes, sir.
All right. And Mr. Goings, would you place your appearance on the record, please?
Absolutely, Your Honor. Nicholas Goings on behalf of Mr. Heiler.
Very good. Thank you. And Mr. Heiler, I'm sure Mr. Goings has told you that if you disagree with the contents of the probation violation report, you're entitled to a hearing. I would conduct that in my courtroom. During the hearing, I would appoint an attorney to represent you. If you'd like an attorney, but you can't afford to hire your own attorney, and your attorney, be it Mr. Goings or a different individual, could cross-examine the probation agent, Ms. Gutierrez, as well as any other police officers or witnesses that might be involved in this alleged violation, as well as use the subpoena power to bring in witnesses who would testify on your behalf. You understand you have that right to a hearing.
Yes, Your Honor, I do.
All right, very good. Mr. Goings, what does Mr. Heiler wish to do at this time?
I understand, Your Honor, that we're going to enter a plea not guilty in this case. He's got the allegations stem from a pending criminal case that is currently pending in Muskegon County. And Mr. Heiler intends to fully obtain due process in that case. And so at this point in time, I'd ask the court to enter not guilty plea, set a bond, and allow Mr. Heiler's underlying matters sort of take precedence before we decide to do anything on this case.
All right. Is that all accurate, Mr. Heiler?
Yes, Your Honor. And I also try to get into Veterans Court and to go back to Miss Green's house because of my dogs, and it's
Yeah. Don't talk too much about it. I don't want anything to
Roger.
get you in trouble in any other underlying case. So, all right, Mr. Heiler, I'll enter your not guilty plea and a waiver of what we call the 14-day rule, although you're not in custody, so the 14-day rule isn't as strictly applied in your case. Normally that hearing might have to be within 14 days. However, when there's a pending different charge, a lot of times people will waive the requirement for 14 days because you don't want to testify in a probation violation hearing and thereby shoot yourself in the foot in a different case pending in a different courtroom. Is that consistent with your understanding, Mr. Allen?
Roger that, Your Honor. Yes, sir.
Very good. Then I will set a not guilty plea and a waiver of the 14-day rule. You are not in custody right now. Is there a bond set in this case currently, or a bond conditions in the Muskegon County case, Mr. Goings?
As far as a bond in this case, no, I don't. This is order to show cause. I don't think there's a bond on this case. I think this is just a summons to appear. As far as the bond conditions in the Muskegon County case, I'm not privy to that information. He's not in custody, so I'm assuming it's either if he was arraigned in Muskegon County, he's probably given a PR bond.
Okay.
I actually, Your Honor, if you mind, there was a bond, and I bonded out. I have a bond agents and everything too, and for Muskegon.
Okay. Is any additional bond warranted in this case, Ms. Herrera? Or Ms. Gutierrez? I am sorry.
No worries, Your Honor. There is a bond. Mr. Heiler's correct. There is a bond set for the case for Muskegon County larceny, $25,000 bond, and he has an upcoming court hearing the 25th, August 25th, if I'm correct, Mr. Heiler.
That is correct, ma'am.
Okay, very good. Well, what I will do then is, based on that not guilty plea, Mr. Heiler, I will have you continue reporting as directed by to Ms. Gutierrez. And Ms. Gutierrez, you're still supervising this. It's not been transferred up to. You live down here, Mr. Heiler, or you live up in Muskegon?
I live down here. I'm trying to go back up to Muskegon. Yes, Your Honor.
Okay, all right. Well, you just keep Ms. Gutierrez informed if your address changes, so you can stay current on probation, so we don't get another non-appearance warrant issued out of probation for you. Just stay in touch with her. When's the next time you need him to report, Ms. Gutierrez?
We have, because he's got a tethered device, we have another agent that reviews.
Ah, okay.
Yeah,
I have to report
follow up.
September September 3rd with Mr. Dominic.
Agent
that's what he
Melton.
told me.
Yep, he was just in front of me on the last hearing. He's our tether agent here in Kent County. Very good. Well, do that, then keep the schedule with Agent Melton. Is that a scram tether or GPS tether I have you on, Mr. Heiler?
GPS tether, Your Honor.
Okay, very good. Then do keep doing that. I don't have any reports of violations on the GPS tether, and just keep probation up to date, and of course the Muskegon County folks up to date as well on where you're living.
Mr.
Yes,
Heiler,
sir.
for the record, it looks like you're scheduled to report September 1st.
Oh, thank you. Okay, September 1st. I'll be there. Thank you.
Yes.
Very good. Thank you all, and I think we're all set for today.
Thank you, Your Honor.
Thank you.
Okay, we are here in the matter of the people of the state of Michigan versus Court Patton, case number 26-04797-FH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on Mr. Patton's request to reduce bond. And I would invite counsel to place your appearances on the record.
Blair Lockman for the people.
Thank you.
Good morning, Your Honor. Michael Anderson on behalf of Mr. Patton.
Thank you. And let's see here. I do have a report, a bond report from Court Services indicating that they are not opposed to a bond reduction, but do not recommend a PR bond. And currently, I think I have bonded set at 10,000 cash. I don't think I set that, but I could be wrong about it. Anything to add on bond, Mr. Lockman?
Well, he was on bond when he committed these offenses, so he's required to have a bond and a cash surety bond. He was on bond for 3 offenses. I don't have an issue with a bond reduction to let him into inpatient, but then he can walk himself right out. And we're talking about an aggravated stalking. He's already had a PPO violation. He's had a probation violation. He's on bond for 3 offenses, including a trespassing and assault and battery, disorderly person. So that would be my concern, is he can walk himself right out of the inpatient treatment, but he can't have a PR bond.
And it's victim safety is the concern here, because some of this involves, what looks like perhaps an attempt to contact the victim. So, okay. Anything to add to that, Mr. Anderson?
Just briefly, that the court rule does not contemplate or recognize, a cash-only bond. The court rule does state that it should be cash or surety. At the decision, based on the decision of the defendant. Second, Your Honor set a bond. I believe the case was in front of Your Honor, the PPO violation and the case that he is on probation for. So yes, he's not eligible for a PR bond, but you did set a bond, I believe, of 2,010% on the PPO violation, which was based on the conduct in this offense. I have had the opportunity to speak with Mr. Patton's mother, which is where he'll stay upon release. If he is, he's also working on getting into Forest View to deal with his mental health issues. The allegation here, I mean, it's technically an aggravated stalking. It's a lot of conduct after a lot of contact after a breakup. There's no, even the assault and battery and the disorderly, they aren't related to the victim in the stalking case. They're related to the person who served the PPO and an argument that happened at that time. He does a very minimal record, even if he were convicted as charged in this matter. He has guidelines, I believe, like 0 to 9 or 0 to 11 at worst. Your Honor, I believe a 10% bond, a lower 10% bond, so that he can post with the direction that he, one, report to court services, and two, signing a release to verify that he's getting the mental health treatment while the case is pending, I think would be appropriate. And would ask Your Honor to set a bond similar to what was set in the PPO violation, like a 2,010%.
Very good. Did I give him a GPS tether condition in that other case?
Your Honor, I'm not aware of a tether condition. There may have been, but I'm not aware if there is.
Okay. All right. Well, I don't want him on 2 tethers, but sometimes in cases like these, where I'm reducing the bond, it gives the victim a little bit of peace of mind, if at least there's that GPS tether in place. It may not prevent phone calls and the like, but it does give you some reassurance that you're going to get a phone call if that person is, near your residence anyway. So I will then go with a $2,000 10% bond with the added condition that if he posts that bond, I would like him fitted with a GPS tether prior to release, with the condition of absolutely no contact with the protected individual in the PPO, alleged victim here, and or her home address. That has to be strictly enforced. And I would like him to also, if he does obtain mental health treatment, provide a release to court services so that he can, they can obtain information that he is in treatment.
Thank you, Your Honor. Should I submit an order, or will? Okay.
Yes, if you'd submit an order. Is that right, Wendy?
Yeah, if you could submit an order, that would be great. I'll send a greeter out to the jail, but if we can have an order as well.
Okay, I'll do that. Thank you, Your Honor. Have a good weekend, everyone.
You as well.
Next is the people of the state of Michigan versus Ben Warren, case numbers 26-02425-FH, 26-2761-FH, and 26-03742-FH. And this hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on Mr. Warren's motion to set bond. The court revoked bond based likely on some additional alleged criminal conduct in this matter or in another matter. And at this time, I invite counsel to place your appearances on the record. Sorry, rapid fire here picks up. I think he's on bond. Is my case is a possession of meth, and I get like 2 more of them, like serial cases coming in. I'm not sure which one triggered me to revoke bond, but one of them did, and I said, "Boy, it doesn't sound like he necessarily is getting the memorandum here." So I do note as I flip through the file here, at some point he posted a $50,000 bond on one of these cases I've got with him. So he does have the ability to post some bond. What's your feeling on what an appropriate bond would be and conditions to accompany that?
It's my understanding that he now has 2 new cases. Jordan said they're factually passive R&Os, and those 2 cases have 10,000 10% bonds. That's why his bond was revoked on the other 3 cases. Jordan said that he never missed court on these 5 cases. He knows he's not entitled to a PR bond, but is requesting a low bond, knowing he has to post 5 bonds.
All right, and Mr. Lockman, what's people's position on bond?
Well, I feel like it might be wasted breath here, but I mean, I don't understand any low bond. He posted 2 bonds on possession of meth and went out and committed another drug offense. Posted bond on that and picked up 2 R&Os. Whether they're passive or not is irrelevant. The fact is at this point, the court's not even doing him any favors because all of these are potentially consecutive to each other. So at some point, we're not benefiting the defendant by giving him a bond that he can make. It actually hurts him. So I understand that the court is going to set a high bond. If he pays it, then he pays it. But I don't know how many cases he has to be charged with before we say he's a danger to himself and a danger to others. So I'm requesting that the court set a high bond, not a low bond, make it a cash surety. Even the 10% bonds on the R&Os to me we're just inviting him to keep committing offenses. And when do we put a stop to it?
All right. Well, and those are fair concerns, Mr. Lockman. Of course, they all presume that in the charged cases, he, will be found guilty or enter a plea of guilty. And of course, the whole bond principle is based on the fact that we presume folks to be innocent until they're convicted or until they plead guilty. I'm well aware that this isn't Mr. Warren's first encounter with the law, as it were. He's got a fairly lengthy record here, although as I examine it, do note that whatever he does, he appears to show up to court when he's supposed to. Appearing in court isn't the main concern. The main concern here is additional criminal conduct. And, as Mr. Lockman points out, this is at least the conduct alleged, and the resisting, obstructing, coupled with the methamphetamine charges is worrisome. Obviously, that can create a dangerous situation for him and for the police officers. So I do believe that, some amount of cash surety bonds are warranted here. But at the end of the day, even the new allegations, of possession of controlled substance, it's primarily hurt himself. And another one of the kind of guidestones or whatever it is, of Michigan laws that, we're not supposed to put people in jail to help themselves. They're supposed to crack that code themselves out in the community. It's mainly danger to other members of the community. And as I said, there is a concern about police officers here, although these aren't the worst R&Os I've seen. They're not causing injury or anything like that, indicating that they would be run-of-the-mill R&Os, as it were, maybe typical for a person who's using meth and doesn't want to go back to jail for it. So in the how many cases do I need to set bond? It's just a one, Miss Lopez?
3.
Or,
The 3.
3 times bonds in these cases. Well, given his challenge in doing the right thing here, or at least apparently staying away from methamphetamine, I will set in all 3 cases, in each case, a bond of $10,000, 10% as the bond. Some advantage to the court because we can recover some of those court costs and fines and stuff out of that 10% bond, and it does give him some incentive to show up and attend to these things. I hearken to what Mr. Lockman says. There may be some argument there that he ought to just stay in jail and build up some credit, in the hopes that he can avail himself of that when he resolves all these matters. But that being the case, that's what we'll set bond for at this time.
Okay, thank you, Your Honor.
Alrighty, good morning once again, everybody. It is TCF Live on a Super Friday. Apologies for the little bit of buffering we had there for a few minutes. That was on YouTube, not on us. We're currently running at about a 3 gigabyte up and download here out of the bunker, so it ain't us, it's on them. But they've been having issues. There's been a lot of DDoS attacks out there, so a lot of servers getting hit hard. Anywho, let's change it up. Let's go down to Florida, to the land of snakes, rats, and the Lord. Wade Mercer.
Mr. Gilbert, good morning. Mr. Gilbert, you're here for first appearance accused of 1 count of battery, domestic violence. Mr. Gilbert, I read the complaint, sir. I've also looked at the criminal history, of which you have none. Your parents, your grandparents, and a stepfather are all in the courtroom, Mr. Gilbert, on your behalf. So I'm going to listen to the attorneys and see what input they have regarding probable cause or other things they want me to be aware of, and then I'll address your bond or your release status. Mr. McDaniel, anything on behalf of Mr. Gilbert?
Your Honor, he's a lifelong resident here of Jackson County. I've talked to Mr. Gilbert, and he understands he's not going to have any contact with his wife while this is going on. He does have another place to live, and at this point in time, we're just asking for some kind of reasonable release option.
Thank you, Mr. Mitchell.
As it pertains to Mr. Gilbert, we're going to leave everything up to the court's decisioning as to his release options.
Okay, so Mr. Gilbert, the complaint is not your typical battery domestic violence. The allegations are.
Here we go again. Did our internet working here, or? I don't know.
See, friends, what I was just saying about like problems out there on the internet. So they're having their issues too. Let's just stick here for a few minutes. They had this a couple of days ago and got it sorted pretty quick. So let's just hang tight a sec.
Went down too, Jake.
Yeah, my
Jake's
VPN
computer went down too, so it may have been I think we're back connected. Sorry, we've had some internet issues the last couple of days. I think that's 3 times in the last 3 days. We've lost it for a few minutes. So, Mr. Gilbert, as I was saying, I'm going to let you pick between a bond and a conditional release based upon the circumstances and your lack of criminal history. If you choose to post the bond will be $2,500 cash or surety. If you want to accept the conditional release, I'm going to offer you a conditional release. For the reasons I've already mentioned, it's entirely up to you. Mr. McDaniel, is there a request for a cash bond in this case?
Yes, Your Honor, if the court doesn't mind.
Mr. Mitchell, what's the state's position on cash bond?
Your Honor, this is a weird situation because we've already been in contact with Mr. Bassford regarding this case. I think our office is going to conflict on this one. So I can't decide on whether or not for a cash bond or not.
Okay. What I'm going to do, Mr. Gilbert, is I'm going to go ahead, Mr.
McDaniel. We'd ask the court to consider a $250 cash or surety bond, and with the court's understanding that we're probably going to post the cash.
Yeah, it's not, and I understand your office's potential conflict, and that makes perfect sense due to Mr. Gilbert's employment, not questioning that at all. I just don't want to treat him differently than anybody else that would be treated, and anybody else would be offered a cash bond with this situation with no prior history on these allegations. So I'm going to let you post a $250 cash bond instead of a $2,500 cash or surety bond. You have a condition of no contact with the alleged victim, no contact at all. Mr. Gilbert, just to be clear, that does not apply to your children. So if someone works out some kind of visitation or exchanges or whatever with your children, if you and she both want to have contact, we'll deal with that in the future. As of right now, no contact with her at all. Mr. Gilbert, I'm sure you've got things you need there for clothing and things like that you need in that residence for work. If she's living in the residence, you've got to have law enforcement accompany you to the residence to get your clothing and things you need for work. If she vacates the residence and she's gone, you can live there. Otherwise, you've got to live somewhere else on a temporary basis. I'm also going to ask the jail to give you a notice for your court date, which will be September the 28th at 9 a.m. will be your court date. Mr. Gilbert, do you have any questions?
No, sir.
Family have any questions? So as soon as the $250 cash bond is posted at the jail, that's where cash bonds are posted, he'll be released. He just needs to stay away from her till this thing gets sorted out. Okay? Yes, sir.
How long is the clothing items around the house? There's only one concern there is going to be a gun safe that he has in the house, and we want to get that out.
Okay. Law enforcement is not going to accompany you. It's not their job to divide property. So a gun safe usually is very heavy. So here's the thing. If she's okay with you getting it, and I say she, the alleged victim's okay with getting the gun safe, law enforcement may stay there 10, 15 minutes. They're not going to stay there 2 or 3 hours because they've got so much other stuff to do. So if she's okay with you getting the gun safe, that's not a problem. They very well may say clothing and things you need for work. That's normally what they do is clothing and things you need for work, but that's between you and them. That's okay. You want to ask a question, ma'am?
She said it was okay if I wanted it or not.
And that's fine. Anything y'all do, if you go, you don't have to have law enforcement involved. If he goes, law enforcement has to be there. The better thing to do is for y'all to go over there and get what he needs. That way there's no allegations, no, concern or whatever. All right. Any other questions? All right, Mr. Gilbert, wish you the best. So
Thank
we
you.
do have.
Thank you, Your Honor.
Yes, sir. We have one more person that has friends or family here, and that's Daryl Johnson.
Do we tell them where they could post the cash bond?
Yeah, I told them they could post it at jail. Y'all free to go whenever you get ready. Thank y'all for coming. Mr. Johnson, good morning. Mr. Johnson, you have an uncle here on your behalf. Mr. Johnson, you're here because you're accused of one count of fleeing and eluding law enforcement. Mr. Johnson, there is probable cause for the charge. Actually, and I forgot to tell y'all this, Mr. McDaniel and Mr. Mitchell, what I should start doing, what I learned at that conference, is give Mr. McDaniel especially a chance to put anything he wants on the record before I make an announcement on probable cause, because obviously you may have some concerns about that. So I've read the complaint, I've read the criminal history. I'm going to listen to the attorneys on probable cause if Mr. McDaniel has any concerns and any other issues he wants to raise. And then I'll listen to Mr. Mitchell and I'll address your bond. The problem is you're already out on bond, it appears, in Leon County case 26-1268 CF. Mr. McDaniel, anything on behalf of Mr. Johnson?
Your Honor, on probable cause, I don't have anything. He does have an arraignment the 24th next week. I guess that'd be Monday at 9 o'clock. And, he intends to be there for the arraignment if the court, lets him out. I just know in the past, Leon County, they're not going to, hold him 7 days. We just asked the court, to possibly let him bond out and show up at that arraignment Monday. That's all.
Thank you. Thank you, Mr. McDaniel. Mr. Mitchell.
First, what was that case number again for Leon County?
26-1268 CF. I did not write down the charges, but it was felony charges.
I gotcha. And
possession of drugs.
I think it was a drug possession.
Yeah,
case.
and I know I'm familiar with how difficult it is to get in contact with Leon County regarding bond revocation. So I'm not asking for a hold. We're just asking for a higher bond, given the fact that he is on bond in that case, and have a condition of no driving.
Okay.
And random UAs. There was also marijuana found.
Okay. Thank you. So, Mr. Johnson, whether the state asks for it is obviously a factor in whether I revoke your bond or I hold you 7 days, but it's not the sole factor. You're allegedly out on bond for committing a felony and allegedly committed a new third-degree felony of running from the police department, police officers termed fleeing and eluding law enforcement. I'm holding you 7 days, whether the state's asking for it or not. I'm going to do that in every case virtually if there's probable cause. I'm going to do it in every case just about. If there's probable cause of a new crime, especially if the new crime is a felony, even if the state doesn't ask for it. I'm asking Mr. Mitchell to notify Leon County and make them aware of the charges. If they don't want to revoke your bond or don't want to ask a judge to revoke your bond, that's up to them. But the allegations are you committed a new felony charge while out on bond from another county. So you've got a 7-day hold with no bond. Now, having said that, you're entitled to a bond in the new case. So I'm going to set your bond in the new case at $10,000 cash or surety. Don't try to post your bond for a period of 7 days because I'm going to see you in 7 days. If Leon County hasn't revoked your bond, then I'll release that hold and you'll be free to post the bond here and be released. If they do revoke your bond, we'll see what the judge in Leon County does, but don't try to post a bond for 7 days for the reasons I've mentioned. Do you have any questions, Mr. Daryl Johnson? And I'll see if your uncle has any questions. Do you have any questions, sir?
Yes, sir. I work. And I didn't commit a felony, but I was scheduled to work today, and I'm not a threat. I've been a high-standing citizen since I've been here. This is where I'm from. I've been a pillar in the community. My father, my family have been a pillar in the community, and I deserve a bond.
I appreciate that position. Your bond request is denied. You're not an outstanding citizen when you've got 2 felony charges pending in 2 different counties. Not right now. If you get found not guilty, good for you. But right now, you're not getting a bond when you just posted bond in Leon County. Let me see if your uncle has any questions. Do you have any questions, sir?
Judge, you said it all. I mean, I just wanted them out, but I can knock them upside the head. But anyway.
Well, if they don't revoke his bond, then he'll be free to postpone in 1 week. But I'm gonna give him a week to do that. Okay. Thank you for coming, Mr. Johnson. Mr. Daryl Johnson, wish you the best, sir.
I should have said that. I should have said we'll leave it up to the hold for the court right there, but I neglected to say that. That's my problem.
No problem. We have State versus Cheyenne Miller next. Ms. Miller, good morning, ma'am. We've got a couple of issues. Ms. Miller, you have a hold for Washington County. The charges in Washington County, ma'am, are new charges of driving while license suspended, death or serious injury, DUI with damage to property or persons, and another DUI with serious bodily injury to another person. So that's what Washington County wants you for. They have no bond on that warrant.
Yes,
the other issue you have is your own probation in Jackson County for DUI. So in Jackson County, I signed a warrant for violation of probation yesterday when we became aware of this, when the probation office became aware of it. So I've got to first get that warrant served. I want this warrant out of our system and shown as served. So listen to Sergeant Applewhite as he serves the violation of probation warrant.
He's been served. She's been served. They served this morning.
Who's? It's not even in the system yet. Who served her?
It's on the whatever I put the warrant. It's on your warrant stuff there. I guess he said. Second page. Whoever signed the hack. Haglin, they said. Oh, that's like the name.
So when I signed it late yesterday, did they put it in the system then?
No, I called the sheriff's office this morning and they come and served it.
Today?
Yes, sir.
Okay. So that warrant's already been served then, Ms. Miller. So I'm appointing the public defender's office to represent you for first appearance purposes. Listen to Mr. McDaniel, ma'am, and we'll see where we go on the Jackson County charge.
Your Honor, I told Ms. Miller she's going to admit that she violated probation, understanding 4 months in the county jail, 1 day credit, whatever being fine is owed on the case. That'll resolve this case today.
You have a fine and court cost left to Mr. Ham. $618.
I was really confused when I looked at the fines that were owed because the month before that it was $200 owed and then it jumped up to $600. I don't know why that would be, but I was like, I don't.
Tell me where you're looking at that at. Mr. Ham looks confused too. Where are you looking at the information you just said? Where's that coming from?
CCIS, it shows on there that, remaining fine was, looked like she'd been paying each month and it was going down. Then all of a sudden that last month it went up. But I could have been looking at it wrong.
Yeah, I don't know. According to Mr. Ham's notes, it goes down every month. She's making payments. It was $718 on June 22nd, and then it went down to $618.
Right.
Okay.
So it says on there like 200 something owed left when they took a receipt down. It's noted on the CCIS by somebody. I don't know who notes that on there. But yeah.
What is that? Is that cost supervision? What's the cost supervision left? 280 cost supervision left. That may be what it is. But all I would order today is, because you're not going to be on supervision anymore, that's not going to be ordered. But I would order remaining court costs and fines. Ms. Miller, let me see if that's agreeable with the state. Mr. Mitchell?
It is agreeable with the state. What's that total amount of remaining fines?
$618. Ms. Miller, did you hear that agreement, ma'am?
I'm sorry, you said $618?
You would be ordered, you would be sentenced to 4 months in the Jackson County Jail.
Okay.
You may or may not get trustee status. That's between you and the jail. You have $618 left on your court costs and fines. If you get that worked off at the jail, great, good for you. If you don't get it worked off, it would be a civil judgment against you. At some point when you get near the completion of your sentence, Washington County will be notified. If they still want you, then they would come and get you. and you'll go deal with that charge. If they don't want you, if you've been able to resolve the case somehow before then you'll be released when you finish your sentence here. Any questions?
No, sir.
Is that the plea or admission you would like to enter on the VOP, ma'am?
Yes, sir. Yes, sir.
Ms. Miller, I'm going to accept your admission that you violated the terms and conditions of your probation in Jackson County Case 26-12 CT. I'm going to revoke that supervision. I'm going to sentence you to 4 months in the Jackson County Jail. I'm going to give you credit for the time that you've already served. And that was how many days, Mr. McDaniel?
1 day.
So she wasn't arrested originally?
She was not.
No, sir.
All right. 1 day credit for the time that you've served, $618 court costs and fines remaining, no probation left. And I have no problem with the jail sending you to Washington County when you get near the completion of your sentence, ma'am, to go ahead and deal with that. So what our jail normally does, ma'am, when you get down around 10 days, 2 weeks, something like that, they'll go ahead and notify Washington County to come get you. So you may actually do the last few days of this sentence in their jail. Did I miss anything? Yeah, she was adjudicated guilty originally because it was DUI, but just to be clear, I'm adjudicating her guilty. I have to. If they're not worked off, the fines will be reduced to a civil judgment, but hopefully get them worked off. All right.
Okay, yes,
Any
sir.
questions, Ms. Miller?
No, sir.
Wish you the best, ma'am.
Yes, sir. Thank you.
Yes, ma'am. We have Justin Morgan. Mr. Morgan, good morning. Mr. Morgan, you're here because you have 3 new charges that have been added in addition to the charges you're already in jail for. You've been accused of 3 counts of sexual battery on a person less than 12 years of age by a person 18 years or older. Those are capital felonies. It's the most serious charge we have in Florida. Mr. Morgan, I've read the complaint. I've also looked at your criminal history, which wasn't bad at all until these recent charges in the last few months. But I'm going to listen to the attorneys and I'll address your bond status. I know that you already have a pretty sizable bond. He also has a no bond on the VOP, correct? Okay, so you're entitled to a bond. I'm going to set this bond today. That doesn't change your bond status in your other cases, though. Mr. McDaniel, anything on behalf of Mr. Morgan related to probable cause or other factors?
No, Your Honor.
Mr. Mitchell.
I can't say for certain if the state's going to file a motion for pretrial detention, given the fact that he's already being held without bond, but nonetheless, we just request the court that make this it's no bond in that situation.
It's not going nowhere.
If you're filing a motion for pretrial detention, I have to hold him for 5 days. And you have a hearing.
I haven't been told that we're going to be doing that.
If you anticipate you may be doing that, then I need to know that now. Otherwise, I've got to set him a bond. He's entitled to a bond. With these charges, an alleged victim of 4 or 5 years old, he's going to get about a $250,000 bond per charge.
Okay. Yeah, that works. We will go ahead and set bond today.
Mr. Morgan, these are very serious charges, sir. Your bond is $250,000 per count. That's in addition to any other bonds you may have been set, sir. This does not change your court date on your other cases. I'm going to ask Mr. McDaniel to notify your attorney in your other cases of the new charges to make them aware of this. So hopefully they'll come see you at the jail. Mr. Morgan, do you have any questions, sir?
No, sir.
Wish you the best, Mr. Morgan.
Thank you.
Yes, sir. Mr. McDaniel, that's everything I had on my first appearance list. Anything else from the public defender's office?
No, Your Honor.
All right, that wraps up the day for Wade Mercer. Good morning once again, everybody. Now in hour 2 of TCF Live. Lindsay, during that, you donated 10 memberships. Thank you so much for that. Very much appreciated. So I'm going to take us back to Judge Elmore, but before we go there, this is a freeze frame from Judge Molly Hennessy Greenwald's court, and all I can say in looking at that is, Carol Ann, step into the light. It would seem they're having some camera issues from the jail in Ingham County this morning. Anywho, let's, like I said, let's go back to Judge Elmore.
Our next case that we're taking up today is People of the State of Michigan versus Dane Alexander Scott. The case number here is 26-14316. Appearances from counsel, please.
Nick Torrance on behalf of the people. Robert Champion appearing on behalf of Mr. Scott, who is appearing via Zoom from DOC.
Thank you. Mr. Scott, are you able to see and hear the court?
Yes, sir.
Thank you. We're here today for an initial pretrial conference. And the counsel informed me that we are taking its entry a plea. Scott, please raise your right hand. Sir, do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may lower your hand. Now, as I understand it, in this particular case, the defendant was he on parole?
No, he was on probation at the time.
All right, thank you.
And he's already been violated as a result of these new charges.
On the probation?
Correct.
Thank you. All right, Mr. Scott, I'm told today that you're going to enter a plea of guilty to counts 1 and 2. Each one of them are a charge of possession, aggravated possession of child sexually abusive material. In exchange for that, several other counts will be dismissed. It includes 1, 2, 3, 4 other charges of the same, which again was aggravated possession of child sexually abusive material, and then a count of using a computer to commit a crime for which the maximum prison of 10 years or more, but less than 20 years would be possible. And the third habitual felony offender enhancement will be dismissed. Is that what you understood so far, Mr. Scott?
I'm sorry, you cut out there toward the end, Your Honor.
It's okay. I'm going to go back through it. Maybe I'll go through it a little bit differently. I'm told that
it was just the very last part you cut out on. All I heard was something, Mr. Scott.
All right. Mr. Scott, you are charged right now on a felony information with 7 criminal felony offenses, as well as a habitual felony offender enhancement. I'm told today you're going to plead guilty to 2 of those counts, and the remainder will be dismissed. So far, is that what you understood?
Yes, sir.
Thank you. We're going to go through that felony information. Counts 1, 2, 3, 4, 5, and 6. Are all charges of aggravated possession of child sexually abusive material. Each one of those is a felony punishable by up to 10 years and or up to $50,000. Plus, there would be sex offender registration requirements. And if you've been on the sex offender registry before, instead of it being a tier 1, it would go to a tier 2 registration. Now, there's also a third habitual felony offender enhancement that could allow the court, after a conviction, to increase that potential punishment from up to 10 years to up to 20 years. However, I'm told today that you're going to plead guilty to only the first 2 counts of possession of child sexually abusive material, which again is a felony punishable by up to 10 years and or $50,000, and registration under the Sex Offender Registration Act is a tier 2. And if you do, and I accept that plea, the other 4 counts of the same nature, same crime, and the habitual enhancement will be dismissed. Additionally, there's this count 7, which is a charge of using a computer to commit a crime, where that crime would have a maximum punishment of 10 years or more, but less than 10 years. So in other words, the allegation is that you used a computer to commit the previous 6 offenses. Now, as a third habitual offender, as a felony, that would be punishable by up to 10 years and or up to $10,000. And as a third habitual felony offender, the enhancement could allow the court, within its discretion, to increase that sentence from up to 10 years to up to 20 years. However, count 7 and the third habitual enhancement will be dismissed. Do you need me to repeat any of that to you, Mr. Scott?
No, sir.
And is that what you believe you're going to do today?
Yes, sir.
Now, when you enter a guilty plea, the court's going to require you to tell me a little bit about what happened to support the nature of the offense. I might need some help from the counsel to be able to have an idea of what the images are to qualify it as aggravated. However, By entering a plea of guilty today, Mr. Alexander, you're going to be given up the right to have a trial. That means that you will be given that you'll be given up certain rights, and those rights include the right to be tried by a jury, the right to be tried without a jury, if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove your guilt beyond a reasonable doubt, the right to have the witnesses against you appear at trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for defense to appear at the trial, the right to remain silent during the trial, the right to not have silence used against you, and the right to testify if you chose to testify. Mr. Scott, do you understand those rights?
Yes, sir.
And even more importantly, do you understand that if you enter a plea of guilty today, and I accept that plea, you'll be forever waiving those rights as they apply to this particular case, sir?
Yes, sir.
Additionally, any appeal as to the conviction and sentence pursuant to this pretrial agreement would be by filing an application for leave to appeal and not a claim of appeal by right. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. Also, you'll be given up the right to claim that the plea was result in some promise, threat, or inducement not told to me right now on the record. Other than the terms of the pretrial agreement, Mr. Scott, have there been any other promises, threats, or inducements to force, compel, or encourage you to plead guilty today?
No, sir.
Are you therefore doing so of your own free will?
Yes, sir.
Now, excuse me, have you had ample time to speak with Mr. Champion about this file and your rights, your options to go to trial, things like that?
Yes, sir.
And are you satisfied, at least up till now, with his representation?
Yes, sir.
Now, I see on this form here, this pretrial agreement that the attorneys have filled out, and I note that it doesn't have your signature, obviously, because you're confined in a prison. It says right here that the estimated sentencing guideline range is between 36 and 60 months. Now, we don't know if that's exactly what it is. I trust the attorneys have done probably a pretty good job at figuring out what that guideline range would be. But you understand that that's just an estimation and we don't know exactly what the guidelines will be?
Yes, sir.
Also, there is no agreement as to exactly what the sentence will be as well. Is that correct?
Yes, sir.
Has anyone promised you or led you to believe exactly what I would do at sentencing?
No, sir.
Do you still wish to enter the plea of guilty that I just talked about a moment ago?
Yes, sir.
As to counts 1 and 2, aggravated possession of child sexually abusive material, how do you plead?
Guilty.
Before I can accept that plea, I'm going to ask you some questions. And I turn your attention to a date range of May 13th and through May 26th of this year, here within the city of Cadillac in Wexford County. At that time, as I understand it, you were on probation, is that correct?
Yes, sir.
And based upon looking at this list of witnesses, and from what I recall from the probation violation, did a probation officer come and examine a phone, a computer, or a tablet of yours?
Yes, sir. Phone.
And okay, and that phone had the ability to access the internet, is that correct?
Yes.
And when he, which probation officer came and looked at the phone?
Lindsay Simmons.
And when she took that phone on it, were there some videos that were child sexually abusive material?
At the time, I didn't believe so, but yes.
Yeah, and had you put them on there, maybe you thought you removed them, but you had used your phone to access them, is that right?
Believe so, yes.
Well, I just want to make sure we're getting there completely. Mr. Champion, maybe you know why there's a bit of hesitation, and I'm going to ask you to take over the question.
Mr. Scott, there were a series of videos on your phone, correct?
Yes.
And you knew those videos and observed those videos on your phone, is that correct?
Yes.
And upon investigation, it was determined that the female that was depicted in those videos was between the ages of 8 and 10. You don't dispute that, is that correct?
To my knowledge, yes.
Here.
1 second. And Mr. Scott, there's one word I want to make sure we use. It appeared to you that the child was of a prepubescent age, is that correct?
I believe so, yes.
All right, thank you. Mr. Carnes, you please provide a factual basis to support the plea? Are you aware of any other promises, threats, or inducements?
No, Your Honor.
Could you report compliance with the court rules?
Yes, sir.
Mr. Champion, you agree with all three?
I do, Your Honor.
Thank you. Well, the court agrees and finds that the defendant's plea today has been made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the required elements of proof for the 2 counts. Therefore, the defendant is found guilty of counts 1 and 2. The remaining counts and the sentencing enhancement will be dismissed at the time of sentencing. All right, Mr. Scott, we'll be back here in about 4, maybe 5 weeks to deal with sentencing. Between now and then, an agent of the Michigan Department of Corrections is going to prepare a pre-sentence investigation report. While you had one prepared earlier this year, this report will include some updated language. They'll still give you a packet, have you complete that packet and turn it in, and then we'll still schedule an interview with you. You have the right to have your attorney present during that interview. Now, again, this report will describe the offense, prior criminal history, the prior performances on probation, bond, or parole, if applicable, and then it will make a recommendation as a sentence. That recommendation is strictly that, a recommendation. It will also include a score into the guidelines. The guidelines are not mandatory in the state of Michigan. However, the court must use them in helping to reach a appropriate, fair, and reasonable sentence. Do you have any questions about that process, Mr. Scott?
No, sir.
Any any bond that was set in this case is hereby terminated. He'll obviously remain in the custody of the Michigan Department of Corrections until we're back here for sentencing. Anything further today, Mr. Carnes?
No, Your Honor.
How about you, Mr. Champion?
Nothing further, Your Honor.
All right, thank you all very much. We are adjourned.
Alrighty, friends, creeping up on the halfway point for TCF Live this morning. Let's go back to Florida. We'll go to Bay County, check in with Brantley Clark.
All right.
Judge, Mr. Hodis is before you in case 24-2774 and 24-3335. In case 24-2774, he's going to withdraw his previous enter a plea of no contest to possession of controlled substance, 3rd-degree felony, punishable up to 5 years in prison, $5,000 fine. Counts 2 and 3 are misdemeanors, punishable by county jail time. The agreement we reached with the state is he be adjudicated guilty as to each. As to the felony count, he be placed on a period of probation not to exceed 36 months. He would pay court costs and fines of $1,078. He would pay restitution of $65 to Dan's Pawn and $365 to Brian Gaynor. Perform 100 hours of community service work at a minimum of 8 hours a month, $20 a month costs of supervision. You'd undergo a drug and alcohol evaluation and counseling that's deemed necessary, and there'd be zero tolerance to the use of controlled substance without a prescription, random UAs at his own expense. He did enroll in Complete Haven House during the course of while we were working this out, and that would suffice for his evaluation and counseling, but he'd still be subject to random UAs. He'd submit to a DNA sample and forfeit any seized items. Department of Highway Safety and Motor Vehicles may apply additional penalties. In case 243335 would be consolidated.
That's the agreement with the state?
Yes, Your Honor.
Promise for the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, so you can lower your hand and state your name.
Christopher Hodes?
Hodes, you heard the announcement from Mr. Meredith, is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir, it is.
Anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning which would impair your ability to enter the agreement or understand any of its terms and conditions?
No, sir.
I've been handed a plea waiver and consent form. There's the front page. On the second page is a signature over the defendant line. Is that yours?
Yes, it is.
Have you had the opportunity to read that agreement?
Yes, sir.
You had the opportunity to go over your case with Mr. Meredith?
Yes, sir.
Have you had enough time to speak with Mr. Meredith about your case?
Yes.
Are you satisfied with your lawyer's advice and counsel?
Yes.
You understand that by entering the plea, you're waiving your right to go to trial.
Yes, sir.
You're waiving your right to require the state prove the allegations against you.
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes, sir.
You're waiving your right to present any defenses that you might have to the allegations.
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify to remain silent at the trial, which would be your decision to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this of your own free will?
No, sir.
Okay. Do you feel?
What was that?
Are you doing it of your own free?
Oh, I thought, yes, sir, I am.
Okay, you want me to accept the plea?
Yes, sir.
You understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea?
Yes, sir.
All right, I'll accept the stipulation, find a prima facie case, find that Mr. Hodes' plea was freely and voluntarily made after consultation with his attorney. I'm going to accept it. He is adjudicated guilty of possession of crack cocaine, count 1, possession of paraphernalia, count 2, and attached license plate not assigned, count 3. On count 1, he's placed on a term of probation not to exceed 36 months, or to pay fines and costs of $1,078. He must pay $65 to Dan Spone and $365 to Brian Gaynor for restitution. In this case, I believe those the cases that the restitution is going to be consolidated, but he's paying the restitution in this case. He must complete 100 hours of community service work at a minimum of 8 hours a month through the Bay County Work Program. I'll give the Florida Department of Corrections the discretion to amend that at the direction of a probation officer. His cost of supervision will be $20 a month. His completion of the Haven House will suffice for his drug and alcohol evaluation, but he will be subject to random UAs at your own expense, zero tolerance for use of any controlled substance not prescribed by a treating physician. You'll be subject to random UAs at your own expense. If you're required to give a DNA sample, you must submit one. Forfeit any seized items. The Florida Department of Highway Safety and Motor Vehicles may apply additional penalties. On the misdemeanors, you're sentenced to the time you serve in the Bay County Jail, given credit for that time. All the sentences are run concurrent. Mr. Otis, if you'll step forward to be fingerprinted and speak with the probation officer, good luck to you, sir. Mr. Matters, you ready?
Good morning, Judge.
Good morning.
Judge, this is a case State of Florida versus Sean Hughes, case number 26-614, CFMA. He's here to enter the pretrial intervention program.
Okay.
So we just need a tracking date. And
let's set this for okay, we'll leave it on September 15th. Is that arraignment? We'll leave it on September 15th at 9 o'clock as a tracking date. Sir, if you're accepted to the pretrial intervention program, you will not have to come back to court. You need to step over and speak to the probation officer and set that appointment. Thank you.
Thank you, Judge.
Are you ready? All right, Mr. Ricardo. Madam Clerk, if you'll swear Mr. Ricardo in.
I do.
Okay.
And this is approaching is Miss Adesema Rodriguez. She's going to be entering a PTI agreement.
Te está acercando la señorita Adesema Rodríguez. Ella va a estar aceptando una intervención antes del juicio.
Our interpreter has gone over all the terms with her, and I believe that we've answered any questions that she has.
Nuestro intérprete ha repasado todos los términos con ella y creo que le hemos respondido cualquier pregunta que hubiera podido tener.
By accepting this, the no contact order with the children that has been put in place by the first appearance judge will go away. So she'll be able to have contact with her children pursuant to any DCF case plan.
Al aceptar este acuerdo, va a expirar cualquier orden de no contacto que haya impuesto el juez de primera comparecencia. Una vez que ella acepte este acuerdo, podrá tener contacto con sus hijos de acuerdo con cualquier plan que tenga con el Departamento de Niños y Familias.
So that will render the motion that we filed moot.
Así que ya no tiene caso la moción que nosotros presentamos.
All right, this time she is released on her own recognizance. I'm going to set this for September 25th. We'll set it for September 5th, September 15th at 1:30. Leave it on that docket for a tracking date. If she's accepted into the pretrial intervention program, she will not have to come back to court.
Bien, en este momento ella está bajo libertad, bajo palabra. Vamos a programarla para septiembre 15 a la 1:30 como fecha de rastreo. Si la aceptan en el programa de intervención antes del juicio, ella no tendrá que venir a esa audiencia.
Good luck.
Buena suerte.
Ma'am?
Señora.
Just step over and speak with the probation officer. Is that all, Mr. Ricardo? Mr. Ricardo, do you have anything else?
That's all I had, Your Honor.
Have a good weekend. Thank you for your assistance.
Thank you, Your Honor.
Ms. Bennett, are you still working on a case? Mr. Henson, Mr. Ramey, y'all ready?
Good morning, Your Honor.
Good morning.
Your Honor, the first case is State of Florida versus Stephanie Smith. That's 24-3100. We had a motion rule to show cause today scheduled. We received a forensic report yesterday, about 85 pages in length. I need to review that and probably look at amending the motion for rule to show cause. I talked to Mr. Sullivan about that. He has no objection to putting on another date.
Are you going to set it for September or October?
September, if you have availability.
September 25th at 9 o'clock.
May I look to see?
Yes, sir.
If I have any conflicts? Judge, I'm currently scheduled in a murder trial that week. It's a short week, so I probably will be in trial that Friday too.
You want to say October 23rd?
Yes, sir. And if we can work out something before then.
October 23rd at 9 o'clock.
Thank you, Your Honor. Next case I have, Your Honor, State versus Michael Mold. That's 26-2203, that Mr. Ferrera's case. We're here before the court on a motion for peaceful contact. I understand Mr. Ferrera has spoken with the alleged victim and she's in consent.
Okay.
That's correct.
All right, I'll grant that motion. And if you just want to prepare a simple order and submit it to the portal.
I will, Judge, and that's all I have. I think that's all Mr. Henson has as well.
Y'all have a good weekend.
Thank you, Judge. Great to see you.
Good to see you too.
Thank you, ladies. Thank you, gentlemen.
Ms. Hummer, Mr. Hatcher, y'all ready? Okay.
First, Your Honor, I have Chandler Vincent with Mr. Sullivan. And those case numbers are starting with 20515 CFMA.
Sullivan?
Oh, he may not be back in here.
He may have left.
I'm sorry, Frank.
All right, I didn't see any recommendations.
No, Judge, I believe,
I think they're due on September 21st.
Okay.
So I think
oh, that's today. I thought they're,
September 21st.
oh, no, it was 30 days from the date of the order, which I believe was August 24th.
It was 60 days, so it's.
The order issued us to respond within 30 days, and then the court would address it in 60 days. I believe the plans are due Monday. I'm working on it. I don't have answers for the court at this point.
And we don't either, Your Honor.
I'm hoping I do by Monday, quite frankly.
Y'all have a good weekend then.
Yeah.
Well, and Your Honor,
Welcome to my world.
right.
All right. So we'll set this for September 25th at 9 o'clock and what happens. Good luck.
Thank you.
Is that all you have?
Oh, no, I have a lot more than that. Your Honor, I also have Hunter Campbell, and that's in 262367 CFMA. Hunter Campbell.
He's set for this afternoon.
I think it was this morning, Your Honor, but I can check.
Hunter Campbell?
Or I'm sorry, Campbell Hunter.
Okay, all right. I got it. Yes. Where we at? What are we doing?
Mr.
Hunter, come on down.
Your Honor, so we filed a motion for peaceful contact with his mother, and she's here today if you'd like to hear from her as well. She's one of the alleged victims.
Any objection?
I haven't, the motion was filed 2 days ago. I have not spoken to the victim.
And it, well,
All right, you just bring her up.
Yeah. I haven't had a chance to speak with her.
You want to speak to her? Just have.
Yeah, I can talk to her.
Just real quick. If you need, we can take testimony if we need.
Sure. She's not going to have any objection, Your Honor.
I wouldn't imagine so.
We'll come back to that one, I guess.
Yeah, just Mr. Hunter, have a seat.
You're just going to talk to your mom real quick. Your Honor, we also have for Gregory R's case, and that's 260286 CFMA. We had filed a motion for an order to show cause for the alleged victim in this case, Miss Paige Ndimi.
All right, she wasn't served with it. Is that right?
Let me check.
Looks like it, I'm assuming it was.
I don't believe that there was a return on it, Your Honor.
Does the state have contact with the victim?
Well, and Your Honor, I'd say during the last depositions, she stated on the record that she does not want to move forward.
That's, yeah, the contact that we've had is that she, for us, our office not to bother her. That was,
what do y'all plan on doing?
that I can't, that's as far as I got. The last contact was for us to stop bothering her and leave her alone.
So she stated that during depositions, she has called my office repeatedly asking us not to contact her anymore. I've shared that with the state.
I can go the next step here, but that's the last contact we had was the same as Ms. Humber has indicated. Called our office and said for us to stop
What you
bothering.
want me to do today?
We'd ask that it be dismissed, Judge. She has repeatedly stated she does not want to
I
participate.
don't know enough about the case. Give me a minute to look at it and we can do something. Mr. White should return on Monday. And
I'm gonna take it under advisement, and also I'm assuming that you're also gonna file a motion to exclude the witness. I'll take that under advisement. Also, we'll set this for September 25th at 9 o'clock. If Mr. White can make a decision prior to that, he can file the appropriate paperwork and it can come off my docket. Take it off the pretrial and put it on the 25th. Are we ready to go back with Mr. Hunter?
yeah,
Mr. Hunter, come on down.
The modifications.
Mr. Hunter, come on down. I'm gonna grant the motion to allow peaceful contact with Mr. Hunter's mother. And then we need another court date.
1019 arraignment.
Okay, we'll leave it on that 1019 arraignment. Don't believe the information, didn't look like the information's been filed yet. Okay. We'll see you then, sir.
Thank you. Your Honor, we also have Tyler Leon, that's 243823. We had filed
What's the last name?
Leon.
Okay.
We'd filed a motion for order to show cause in that case previously. I think that we're going to be able to come to a resolution on this one.
Okay.
Have an updated offer.
All right. You want to set this maybe for the 15th?
Yeah.
September 15th at 9 o'clock.
Your Honor, I also have Billy Wayne Henley Jr.
We saw Miss Bennett on Zoom earlier. That's who. There she is.
Okay. And is she the one who?
Correct. And
yes,
I was able to get in touch with Miss Bennett. She explained to me that she hadn't received service on some of these depositions. The one that our office had served from our investigator had gone into her spam inbox and she didn't see it. I have spoken to her. She says she will make herself available. She is now out of county, so we'll try to coordinate a way of getting her to the depositions, but she has told me, and if you wanted to inquire
Why
anything.
don't y'all have them served personally?
I'm sorry, Judge.
Why don't you have them served personally? Nobody ever does that anymore? You just do it by email?
Well, in Your Honor, we had served the police department. We had sent it.
I'm talking to the state attorney's office that you tried to.
There was one that I saw that our investigator tried to serve. I don't know.
But y'all serve them by email?
Some of them, yes. If people accept service by email, I don't know. That was something.
Is that legal service?
If the person accepts.
If the person, you send it, and if they say that they accept it, then it is. But so if they don't accept it, then it's not.
Well, we have just.
But Ms. Bennett is a former law enforcement officer, and I think part of the mix-up was that the agency was being served, and I don't know that was getting through to her.
Ms. Bennett, let me do this. I'm gonna hold this under advisement. I am going to direct the state attorney's office to get up with you, set a deposition. If they need to serve you personally, let them serve, or they can serve you personally. If not, if you'll set it by email, that's fine too. But I'm gonna set this for October 23rd as a tracking date to see if that's happened.
And I believe we've figured out our communications issue. Now we have a good contact number for her and a good email, so we should have all of our issues fixed here.
All right. Don't make it hard on me. I know that. Gosh,
Your Honor, I also have Brandon Collins, and that's 2025-0267.
Colin, okay, Ms. Bennett, that concludes your hearing. And if you're in the Zoom room, if you'll please mute your microphones. All right, what are we doing on Mr.?
Your Honor, may we approach this real quick?
Sure.
Alrighty, friends, we will keep an eye on Judge Clark's courtroom. Might come back later. Let's head back up to Michigan, though. Check back in with Judge Elmore.
All right, we are on the record now for the 28th Circuit Court here in Wedgwood County. We're taking up the case of People of the State of Michigan versus Jamaria Jackson. Case number is 26-14213FH. Appearances, please.
Joanna Carey for the people.
Good morning, Your Honor. Marie Vandenberg for Mr. Jamaria Joseph Jackson.
Thank you. And Mr. Jackson appears today via Zoom as well. Mr. Jackson, are you able to see and hear the court?
Yes, sir.
Thank you. We are here today for a final pretrial conference. This case is one of those set for trial coming up here in about 10 days. And looks like we have a pretrial agreement. I have a written agreement in front of me. The defendant is currently charged with a couple counts, and he's going to be pleading to one of those two counts. Is that correct, Ms. Carey?
It is.
Now, other than the dismissal of the other count, are there any other terms to the agreement, Ms. Carey?
There are not.
Thank you. Ms. Vandenberg, is that what you understand?
And that is my understanding, Your Honor. I do take note that the prosecutor does not oppose a probation period with no upfront jail time, but she does indicate also in the plea agreement that this is not a sentence agreement. Just for the record, Your Honor.
All right, so it's not necessarily a Killebrew agreement. I know I don't take Cobb's agreements, but is that correct, Ms. Vandenberg?
That is correct, Your Honor.
All right, thank you. All right, Mr. Jackson, please raise your right hand for me. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, sir.
You may lower your hand. Mr. Jackson, looking back on December 8th of 2024, were you on probation, parole, or bond anywhere at that time?
No, sir.
Now, you are currently charged on a felony information, which is simply a charging document. And on that document, you are charged with 2 counts. Count 1 is possession of a controlled substance, heroin, which is a felony punishable by up to 4 years and or up to $25,000. Count 2 is a charge of possession of the controlled substance, cocaine. That is also a felony punishable by up to 4 years and or up to $25,000. I'm told that you're going to plead guilty today to count 2, which again is the possession of cocaine. And if you do, and the court accepts that plea, the prosecutor agrees to dismiss count 1. Is that what you understood so far, Mr. Jackson?
Yes, sir.
Now, before entering this agreement and talking about it with your counsel, before entering into this agreement, have you had the opportunity to speak with your counsel, Ms. Vandenberg?
Yes, sir.
Has she told you and talked to you about the case, the evidence against you, your rights, and your options?
Yes, sir.
And are you satisfied with her representation as up till now?
Yes, sir.
Now, if you enter a plea of guilty today, and I accept that plea, you'll not have a trial of any kind, and you'll be given up the rights that you would otherwise have a trial. That includes the right to be tried by a jury, the right to be tried without a jury if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for defense to appear at the trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify if you chose to testify. Mr. Jackson, do you understand those rights?
Yes, sir.
Even more importantly, once again, do you understand that if you enter a plea of guilty today, and I accept that plea, you'll be forever waiving those rights as they apply to this particular case? Understand?
Yes.
All right, thank you. Any appeal as to the conviction and sentence pursuant to this pretrial agreement will be by what's called filing an application for leave to appeal, which is different than a claim of appeal by right, which is an automatic right to appeal, and it's only allowed when someone's convicted at a trial. Furthermore, you may be given a right to appeal issues that would only be appealable if you were convicted at a trial. You also will be given the right to claim that the plea was a result of any other promise, threat, or inducement not told to me today on the record. Other than the terms of the agreement that we've already discussed today, you and I, as well as the counsel, have there been any other promises, threats, or inducements to force or compel you to enter this plea?
Oh, sir.
You enter the plea, therefore, of your own free choice.
Yes, sir.
Now, on this written pretrial agreement, there's a line here at the bottom on page 1 that says the estimated sentencing guideline range is as follows. And then it says 0 to 9 months. The Michigan sentencing guidelines establish a minimum end of a sentence for only a felony. Those guidelines are not mandatory to be followed, but they must be considered, which the court does before issuing a sentence. I highlight for you that it says estimate or estimated because we do not know exactly what the guideline range will be. Now, the counsel, I trust, are well knowledgeable and probably are about right. But the key here is again, we don't know exactly what they are. They are not necessarily mandatory. However, the court generally follows them. Understand?
Yes, sir.
Has anyone led you to believe or made a statement or told you exactly what or what they think I'm definitely going to do as the sentence?
No, sir.
Therefore, do you still wish to enter the plea as we discussed earlier?
Yes, sir.
As to count 2, possession of the controlled substance cocaine in an amount less than 25 grams, how do you plead?
Guilty.
Before the court can accept that plea, I'm going to have you tell me what it is that you did that makes you guilty of that offense.
Yeah. Does that count?
All right.
Standing for not there anymore? No. She's coming back in.
Okay.
Yes, my apologies.
It's okay. That's all right. So,
Okay.
Ms. Vandenberg disappeared briefly from Zoom.
I did.
Clerk stopped us. All right. So, Mr. Jackson, turning your attention to December 8th of 2024 in Colfax Township here in Wexford County. Were you in that township in Wexford County on that date?
Yes, sir.
And were you found to be in possession of a controlled substance?
Yes, sir.
Where was it found?
If I'm not mistaken, because it was so long ago, I believe on my person.
Okay, like in pockets or something like that?
Like my sock, I believe, like somewhere around there.
Okay, so here's the key question. Was it in your possession, your control?
Yes, sir.
And did you know that that substance was cocaine?
I did, yes.
All right. So what kind of container or packaging was it in? Was it in like a Ziploc jeweler baggie or something else? Can you tell me?
Like a baggie.
All right. And so could you see through the baggie and actually see that it was there? Feel it?
Excuse me?
Or feel it?
Oh,
how did
you? Actually, I forgot it was even there. So.
Okay.
Yeah.
Go ahead, Ms. Vandenberg.
Oh, thank you, Your Honor. May I question Mr. Jackson? Sure. Okay,
of
Mr.
course,
Jackson. Thank you, Your Honor. Mr. Jackson, in Colfax Township, Wexford County, you were in possession of the controlled substance cocaine. Is that correct?
Yes.
And that cocaine was found on your person, which means it was in a pocket or in a sock, but it was on you, on your person. Is that correct?
Yes.
And that cocaine was in a small, like a baggie. Is that right?
Yes.
And it was in your person, and it is against the laws of the state of Michigan, correct?
Yes.
And you were aware that that cocaine was in your possession, correct?
Yes.
You knew it to be illegal, is that correct?
Yes.
Are you asking the court to accept your guilty plea to count 2, controlled substance, possession of cocaine?
Yes.
Thank you. Thank you, Your Honor.
Thank you, Ms. Vandenberg. Ms. Carey, do you believe you provided a factual basis?
I do.
Are you aware of any other promises or inducements?
Yeah.
And you believe the court's compliance with Protocol 6.302?
Yes, sir.
Ms. Vandenberg, do you agree with all 3 of those statements?
I do, Your Honor. Thank you.
Thank you. The court agrees and finds the defendant's plea is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the required elements of proof. Therefore, he is found guilty of count 2. Count 1 will be dismissed at the time of sentencing pursuant to the pretrial agreement. All right, Mr. Jackson, we will be back here in about 4, maybe 5 weeks on a Monday morning when this court typically does its sentencing. Between now and then, you're going to complete a packet that you'll receive from the Michigan Department of Corrections, which is also known as the Probation and Parole Office. You will complete that packet, turn it back in, and then you'll be subject to an interview with someone from that office. You have the right to have Ms. Vandenberg present during that interview. Once this report is prepared, they're going to send it to your counsel and the prosecutor and the court. We generally get them about anywhere from 10 days to 2 or 3 weeks before sentencing. Ms. Vandenberg's going to need to make sure that she can contact you because she has to go over that report because each side has to come back to this court and make objections or request corrections to the report. Do you understand?
Yes, sir.
All right. So the court orders you that you must comply with this this PSI report. Again, the report's designed to tell the court about the plea, facts behind the case, any prior criminal history you may have. It will make a recommendation as to the sentence, which is strictly a recommendation, and it will include that score into the guidelines, which again, I told you earlier, are not mandatory. Ms. Carey, any objection to the continuation of bond?
No, thank you.
Anything further on behalf of the defendant, Ms. Vandenberg?
Nothing further, Your Honor. Thank you.
Thank you. All right, bond hereby continues. And again, Mr. Jackson, make sure you keep in contact with Ms. Vandenberg, okay?
Okay.
Thank you. We are adjourned.
Good morning once again, everybody. It is hour 2 of TCF Live. I hope you're all enjoying the show thus far. Let's stay in Michigan, but let's go to Crawford County. We will check in with Judge Colin Hunter.
Department, Mr. Seeger, I know that you're here as duty attorney for purpose of the arraignment. Have you been able to talk to Mr. Campbell?
I have, Your Honor.
All right, Mr. Campbell, do you understand the nature of the allegations that have been made against you in each of these probation violations?
Yes, Your Honor.
Do you understand the maximum penalties associated with each of the charges?
Yes, Your Honor.
The court will enter a not guilty plea on behalf of Mr. Campbell and set this matter for a contested hearing. Mr. Campbell, you have a right to a contested hearing regarding these matters, and at that hearing, the prosecutor bears the burden of proof. The burden is preponderance of the evidence. You also have a right to be represented by counsel. If you could not afford an attorney, one would be appointed for you. Mr. Seeger, has he been screened for indigency?
He has previously, Your Honor. Based on his current economic situation, and because he already has court-appointed counsel, I would approve it, and I'll assign myself, even though I'm not the attorney of record, based on his request.
All right, the court will accept that. We'll have Mr. Seeger appointed then to represent you, Mr. Campbell. Mr. Seeger, I'm going to take some argument or hear some argument regarding bond from first the probation staff and then from you. Is there anything else you need to have covered before we consider bond?
No, Your Honor.
All right, in terms of bond, Ms. Wagner, did the department have a suggestion?
I do, Your Honor. Your Honor, just put him on probation for 2 felonies, one being a 10-year and one being a 4-year maximums on 7/20 of 2026. Several days later, new bench warrants were issued for new felony behaviors that occurred while he was on bond for the offenses that he was put on probation for. Several days later, while in the jail, he made some very concerning, threatening comments to jail staff that he was going to kill or harm Judge Boudet, who presided over his new court cases. Those are very concerning. The defendant has a very, very lengthy history. I think the court at sentencing could have clearly sentenced him to prison, but given him the benefit of probation and jail time to be held in abeyance for him to get into residential treatment. And now his behavior has unfortunately escalated. So he's currently sitting on $100,000 cash surety bond on the new felony cases that are still in district court. I would just ask to the court to adopt that same bond on each file or higher. Thank you.
To be clear, though, you're saying the new charges, that's a carrying concealed weapon and possession of methamphetamine, happened before I imposed sentence, before he was on probation, because he was on bond, correct?
Correct, Your Honor. Yes, those, I think, incidents alleged to have happened back in May, and you sentenced him July 20th, and I think the warrant came out several days later.
Thank you for that clarification. Mr. Seeger, did you have argument related to bond?
Your Honor, just by way of bond, I would ask that the court impose a small bond to ensure that he receives credit, but I don't know as if a $100,000 bond is required in as much as currently he's unable to post his other bond. Additionally, he is entitled to a presumption of innocence. I'm not really entirely sure what happened with the other matters, but just looking at the alleged violation, I'm not entirely convinced that that's a probation violation, but that's something that the court, even looking at it in a light most favorable to the prosecuting attorney's office, but that's something that would have to be inspected in advance of the hearing. To my understanding, Your Honor, he has court, I think, on September 10th, or at least that's what he said. What's happening with that file, I can't say. Clearly, the matter's not been bound over if it's a felony, Your Honor, and it's not a subset of the allegation because he wasn't on probation at the time either. And so I would say that that bond has already been contemplated, and if Mr. Horowitz is able to adjust it, that's fine, but that's between the district court and Mr. Horowitz. In terms of this bond, I would just ask the court to set a nominal bond with the knowledge that he is entitled to a presumption of innocence. And even assuming, arguendo, that the allegations are true, I would suspect that it was maybe related to him allegedly making statements out of frustration. It wasn't a situation where he directly contacted anyone. So I would just ask the court to take that into consideration when setting a bond, but just make it nominal so that at least he's receiving credit. And then additionally, Your Honor, I would ask the court to consider kicking this down the street a little bit only because I'm not sure how the other file is going to resolve. What I did tell him is that you wouldn't receive credit if the court imposed a sentence. I don't know what its findings will be, and even if it did find in a way that is adverse to his position, you know, what the sentence ultimately would be. But I don't, his file in district court is clearly not caught up to circuit court if that's where it's going.
Several different points that the court will make. First and foremost, I disagree with any legal argument, Mr. Campbell, that somehow a probation violation is improper based upon the alleged threats to kill a judicial officer. They're entirely appropriate in my justification. That's why I signed them as probation violation orders. Because one of the things that you're required to do while you're on felony probation, among very many other things, is follow state law. And the violation of state law by threatening to kill is clear. The secondary allegations that are made relating to controlled substances and carrying a concealed weapon are also extremely concerning to the court. They're concerning to the court in a different way, however. You're not subject to any of those charges in the context of these cases because you were sentenced before. But I remember very clearly, Mr. Campbell, you and I having a conversation at your sentencing hearing. And one of the arguments that your attorney strongly made at the time of that sentencing hearing was that I should take into account positively, and I was convinced to do so, that you had been pulled over multiple times and had no problems while you were on bond leading up to sentencing. That information, according at least to the new allegations, was patently false. Because according to at least the allegations made by the prosecutor's office now, you were pulled over, you did have a concealed weapon, and you did have methamphetamine. While your attorney's right that you're presumed innocent on those charges, it brings into question all of the lenity that I showed at the prior sentencing hearing. In other words, if I was misled by you or your attorney, and whether or not I know that your attorney was aware of it, I don't. But if I was misled by you in order to grant you a lenient sentence previously, that's something certainly that I take into account and will take into account if you're found in violation of any probation violation. So while your attorney's right that there is a presumption of innocence, the circumstances of the charge appear to me to be clear. And when one of the bond conditions, one of the primary bond conditions is protection of the public, and we have here a felony probationer who allegedly, soon after you putting on probation, threatened to kill a judicial officer, those are not circumstances I'm willing to treat lightly, despite the fact that they're allegations and despite the fact that you have a presumption of innocence. I'm also not willing to set this matter out a predominantly long amount of time. In other words, while your attorney might have some factual argument as to why it could benefit you, I intend to have this matter resolved. If your attorney's right that you're not going to have, the people are not going to have enough evidence to prove a violation, then I want to make that determination sooner than later. Because if they can't meet their burden, then you shouldn't be held on these charges and or these probation violations. But if they can prove those charges, then the likelihood of me continuing on probation is relatively low given everything that I've said. And I intend to make that determination sooner rather than later. So the court is going to set this matter for a probation violation hearing at my next available.
Why do you do that to me, judges? That's rude. We've talked about this. Every judge out there should know TCF's stance on this. Stop deleting your stuff midstream. Okie dokie. Back to Bay County, Florida, Judge Clark.
For the hearing. Mr. Collins, you just step over and sign a notice and stay in contact with your attorney.
Your Honor, I also have David Cherry, and that's in 25-2239.
Cherry? We're set for a competency hearing today, is that correct?
Yes, Your Honor. If myself and Mr. Ferreira could approach 1 second, sorry.
All right, we're a couple minutes in the Wayback Machine with this court, so let me try to bump past this little sidebar here.
Of that.
There we go.
We're going to set this for a competency hearing on September 25th.
Right. Thank you. You'll go right there and wait for a second. I'll come talk to you, okay? And I believe that's all I have this morning, Your Honor, but I will check really quick.
All right.
Yes.
Ms. Downing has something said. Is she going to be here or do you know?
I'm not sure, Your Honor. I can check with her.
Okay. And she may be here. I don't know. All right, let's see. Ms. Bennett, are you ready?
Good morning, Judge.
Good morning.
We're here for Harold Mangum. And he has Bay County cases and he has one Calhoun County case that we asked you to also resolve. The plea conditions are the same for all, just the charges are different. Mr. Mangum in this Bay County cases are 24-3074, 25-3136, and 25-3271. He will plead no contest to the following in case number 3074. One count of sale of methamphetamine, one count of possession of a controlled substance, and one count of possession of paraphernalia. In case number 25-3136, he will plead to one count of grand theft of a firearm. In case number 3271, he will plead to one count of felon in possession of ammunition. I believe that's constructive, possession of a controlled substance, and possession of paraphernalia. He will be adjudicated guilty on all of them and sentenced to 48 months DOC. The sentence shall be concurrent with one another and with the Calhoun County case that we will mention in a minute. Court costs and fines at the standard rate will be a civil judgment. He's entitled by agreement to 465 days jail credit on all of them, but the misdemeanors, which will be a time served. He will also be adjudicated guilty on the misdemeanors. He will submit a DNA sample. The defense stipulates for purpose of the plea. The defendant agrees to the cost of prosecution, forfeit any seized items, no contact with any victims, and he understands that the Florida Department of Motor Vehicle may impose additional sanctions. Do you want this or do you want me to read it? The Calhoun County case is case number 25-4319. He will plead no contest to one count of burglary of a structure or conveyance. He will be also adjudicated guilty and sentenced to 48 months DOC. This will be concurrent with the Bay County cases just mentioned. Court costs and fines will also be a civil judgment, and 465 days of jail credit will also be awarded in that case.
You have the score sheets for Calhoun County?
I do not. I'll submit one.
Okay, but you're in contact with who?
I haven't got, yeah, but I've received an email approving.
Okay.
As a resolution, which
we need to get all that
easier so he doesn't have to go back to Calhoun.
Yeah, and I'm fine with it. We just need to get all that information to the clerk's office.
I will.
Mr. Clare, do you represent Mr. Magnum in the Calhoun County case? Okay. Do we have the cost in Calhoun County?
We used the Bay County cost sheet and just wrote Calhoun County in.
Honor, they're doing it pro bono for the Calhoun County, just to help him out. So I don't think if any court costs should be at the public defender rate.
Okay. All right. I don't mind doing that. I just, is this 518? Is that the,
That's the additional cases for Bay County.
and the 1253 is Calhoun County? All right. All right, what I'll do is,
Y'all be quiet in the audience area, please.
1,078.
Thank you, sir.
All right. I'm gonna charge him 1,078 for the Calhoun County case. I don't know if that's there. Yeah, 1,028, I'm sorry. 1,028. I don't know if that's what they charge or not, but that's what they're gonna get.
Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
All right, sir, you can lower your hand and state your name.
Earl Mangum, Jr.
Magnum, you heard the announcement of Ms. Bennett, is that correct?
Yes, sir.
Is that your understanding of the agreement with the state? Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol today which would impair your ability to enter the agreement or understand any of the terms and conditions of it?
No, sir.
All right, I'm going to show you two plea waivers and consent. This is the Bay County case. That's the front page.
Yes, sir.
And on the second page is a signature of the defendant line. And on the Calhoun County case, it's the burglary of a structure or conveyance. There's the plea waiver and consent form, and on the back, the signature of the defendant line.
Yes, sir.
And you saw both those signatures,
Yes, sir.
and they're both yours. And you've had a chance to go over the plea waiver and consent forms. Is that correct? And you've had a chance to go over your case with Ms. Bennett, and I'm assuming also with Ms. McLaren.
Yes, sir.
Have you had sufficient time to speak with your lawyers about the case?
Yes, sir.
Are you satisfied with their advice and counsel?
Yes, sir.
Do you understand that by entering the plea, you're waiving your right to go to trial?
Yes, sir.
You're waiving your right to require the state prove the allegations against you.
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence. You're waiving your right to present any defenses that you might have to the allegations.
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify to remain silent at the trial, which would be a decision you'd have to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this for your own free will?
Yes, sir.
Magnum, do you feel this pleas in your best interest?
Sir.
You understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea?
Sir.
Mr. Ferrer, Ms. Bennett, and Ms. McLaren, state or defense aware of any DNA evidence that exists which might tend to exonerate Mr. Magnum?
No, sir.
Is there any restitution in any of the cases?
No, not on the Bay County cases. I don't believe there is any on the.
Okay, all right. And a prima facie case, please.
All right, Your Honor, the state is created proven case number 243074. On September 17, 2024, the defendant sold methamphetamine to a undercover police officer that later tested positive as well. And on September 17, 2024, he was found to be in possession of 1,4-butanidol, a controlled substance. And in case number 253136, on September 30th of 2025, the defendant took possession of a firearm, which was the property of James Herzog, with the intent to deprive James Herzog and others of proper use of that. And on case number 253271, on October 15th of 2025, the defendant was found passed out in a car. In that car, he was in constructive possession of ammunition after having been convicted of a felony in the state of Florida. He was also found to be in possession of 1,4-butanidol again. And in the Calhoun County case, number up, on June 16th of 2025, he entered into a property of 3868 Northwest Charlie Fincher Road without permission to be there.
I'll find a prima facie case. I'm going to find that Mr. Magnum's plea was freely and voluntarily made after consultation with his attorney. Is there any reason I'm going to accept it? Is there any reason we can't go forward with sentencing?
No, Your Honor.
No.
In case number 24 CF 3074, 25 CF 3136, and 25 CF 3271, those are the Bay County cases. He's adjudicated guilty of selling methamphetamine, possession of a controlled substance, possession of paraphernalia, grand theft of a firearm, felony possession of ammunition, constructive possession, possession of a controlled substance, and possession of paraphernalia. On the felonies, he is sentenced to 48 months in the Florida Department of Corrections to run concurrent with each other. He's given credit for 465 days time served. He's ordered to pay fines and costs of $1,078. Those include discretionary costs of $2 of local law enforcement education, a $65 assessment additional court cost, a $150 discretionary public defender fee payment, a $50 drug abuse trust fund payment, and a $200 discretionary fine. There's also an additional fines and cost of $518 for the two other case numbers. Those include discretionary cost of $2 of local law enforcement education and a $65 assessment additional court cost. Those fines and costs are reduced to a civil judgment. On each of the misdemeanors, he sentenced the time he served in the Bay County Jail, given credit for that time. The sentence was run concurrent. If he's required to give a DNA sample, he must submit one. He's to have no contact with any victims. He's in the Florida Department of Highway Safety Motor Vehicles may apply additional penalties. Yes, sir.
And all other counts have been consolidated.
Okay.
Put that on the.
Yes, sir, you may. In case number 07-2025-4319, this is the Calhoun County case. He's adjudicated guilty of burglary of a structure or conveyance. He's sentenced to 48 months in the Florida Department of Corrections, given credit for 465 days time served. He's assessed fines and costs of $1,028. Those include discretionary costs of $2 of local law enforcement education, a $65 assessment of additional court costs, a $150 discretionary public defender fee payment, and a $200 discretionary fine. Those fines and costs are reduced to a civil judgment. This sentence will run concurrent with the sentence received in the Bay County cases. There's no restitution after in the case. Have I left off anything?
I don't believe so.
Mr. Magnum, you have 30 days to file your notice of appeal. If you wish to appeal this judgment sentence, you'd like to have an attorney to represent you, and you can't afford one. One may be appointed to represent you at no charge. Good luck to you, sir. You need to step over and be fingerprinted.
Thank you, Judge.
Yes, ma'am.
Alrighty, friends, now hour 3 of TCF Live on this glorious Super Friday. It is good to have you all here with me. Sometime during the bottom of the hour here, we will go to Dungeon Court. If you are new to this channel, stick around for that. Dungeon Court is the best, worst court you'll ever experience. It is our Friday guilty pleasure here. But for the moment, let's go to North Dakota. Judge Thornton is getting his day started.
August 21, 2026. Time is now 10:09 a.m. My name is Nick Thornton. I'm a district court judge for the Southeast Judicial District, which includes Barnes County. We're conducting today's hearing in part in person and in part by reliable electronic means. The matters are venued in Barnes County. The Barnes County courtroom is open to the public. The Barnes County courthouse is open to the public. Because we have individuals appearing by reliable electronic means, we're also live streaming today's event on the Southeast Judicial District's live stream YouTube channel. Again, these are open and public proceedings. We have on the court's docket a couple of orders to show cause or warrant appearances in essentially contempt proceedings. I'm about to read the contempt rights for those individuals appearing on those types of hearings. And then I do have a bail review as well. We'll take that up at the end. So for those that are appearing on orders to show cause or warrants issued due to non-appearances at orders to show cause, the court treats those actions essentially as contempt proceedings. The primary purpose of contempt is to sanction conduct and condition performance or non-performance of an act required by a court order, and to induce compliance with the court's orders, or to unconditionally punish contemptuous behavior to vindicate the court's authority. Contempt includes intentional non-payment of money ordered to be paid where execution is not possible. It also includes any act or omission specified by law as contempt. Failure to comply with the child support order is, by law, contempt under North Dakota Century Code Section 1408.1, sub 15 or Section 15. For those that are appearing on contempt proceedings, you have the right to be personally present in court, the right to reasonable notice of any allegations against you in order to show cause or a warrant of attachment. You have the right to bail if a warrant of attachment is issued. You have the right to attorney representation and consultation. You always have the right to privately retain counsel. You have the right to proceed without counsel and represent yourself. If jail is a potential consequence, you have the right to a public defender if you financially qualify for one. You have the right to reasonable delays to prepare for an evidentiary hearing. You have the right to an evidentiary hearing and an opportunity to be heard. The standard of proof and the burden of persuasion rests with the movant. The movant must show by clear and convincing evidence if the court intends to use remedial contempt sanctions that your conduct was willful, intentional, inexcusable, and unjustifiable. The defendant or respondent bears the burden to establish any applicable defenses by preponderance of the evidence, for instance, justification for noncompliance or impossibility. Those are defenses that you bear the burden to establish. The rules of evidence apply in contempt proceedings. You have the right to confront and cross-examine witnesses against you. You have the right to testify or to remain silent, present evidence and call witnesses, and to use the court's subpoena power to force those witnesses to appear. First matter the court is going to take up will be criminal order to show cause bench warrant appearance in state of North Dakota state of North Dakota versus Tyson Michael Tormey, 02-2025 CR 83. Present in court for the state, Attorney Trent Jackson. Mr. Tormey appears by reliable electronic means from the Barnes County Correctional Center without counsel. Mr. Tormey, were you present in court when I read you your rights? The jail is muted, so I didn't hear Mr. Tormey's response.
Yes, Your Honor.
So you were present and you understand your rights, sir?
Yes, Your Honor.
All right. And so in your case, there is no attorney that is appearing right now. What's your plan for an attorney? Do you plan on hiring a lawyer? Do you plan on applying for a public defender? Do you plan on representing yourself, sir?
I'll represent myself.
Has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to waive your right to counsel, sir?
No, Your Honor.
Court will find a knowing and voluntary waiver of the right to counsel. Sir, in your case, there was a criminal judgment issued back in April 2025, record index 25. Thereafter, the judgment required you to pay a certain amount of money. In your case, I believe there's a significant amount of outstanding restitution. There have been delinquent notices mailed to you on numerous occasions indicating that you have not complied with the court's payment plan. There was a notice of appearance, there was an appearance required. The court issued a delinquent notice with a hearing date on July 16, 2026, record index 37, requiring you to appear on August 12, 2026 at 11 a.m. to show cause why the court should not hold you in contempt for non-payment. It shows an outstanding balance in the amount of $4,750.44 at the time of August 12, 2026, 11 a.m. You did not appear. The court issued a bench warrant pursuant to that non-appearance and required you to personally appear in court. Do you understand why you're present here or why you're brought to court, sir?
Yes, Your Honor.
All right. And so we can move forward today if you prefer, or I can schedule another hearing. How would you like to move forward, sir?
I'd like to move forward today.
All right. And because today wasn't noticed as the order to show cause hearing, I want you to understand that you'd have the right to request a later hearing where you could present evidence and be prepared to respond, or we can waive that and move forward today. And it sounds like that's what you want to do, sir?
Yes, Your Honor.
All right. So to the allegation that you failed to comply with the payment plan and failed to appear when required, you admit or deny that allegation, sir?
I admit.
Okay. Has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to admit to the allegation?
No, Your Honor.
Okay. And so you're saying you admit that you still owe $4,500, give or take?
Yes. I'm on a payment plan, and I was sent a notice that if the $750 wasn't paid by 11 o'clock on the 12th, that I would have to appear. I sent an electronic payment of that. It wasn't my intention to not appear. I was just under a misunderstanding that if the payment was brought up to that $750 before 11 o'clock, that I wouldn't have to appear.
All right. And you're saying you made a payment before court?
Yes, Your Honor.
I see that payment was made on the date, but it doesn't give me a time, so I don't know if you paid it before or after, but I'll take your word at it. The warrant is quashed. And sir, you intend to comply with the payment plan moving forward, right?
Yes, Your Honor. I will take better care. I've just had some financial things that have come up, which is no excuse, but I will stay on top of it because I know it's my obligation and I don't want to not fulfill that obligation.
Understand that the court will issue a warrant if you don't keep complying with that payment plan, sir.
I do, Your Honor.
And it's no fun getting picked up by law enforcement and brought to the jail waiting for a hearing, right?
No.
No. So
Right.
let's make sure that let's make sure that you keep up with the payment plan.
I will.
Anything else for the state?
No, Your Honor.
This matter is adjourned. Have a good day. So the jail can process Mr. Tormey out.
Thanks, Your Honor.
All right. Next matter the court's going to take up, I'm sorry, wait a second here. Chandra R. Perth versus Brad E. Green, 02-2025 DM75. In this case, Mr. Jackson, are you making a special appearance for the state on this matter? It is a 4D child support case.
Your Honor, I do not believe that either I nor Miss Duffy would be on this case.
Well, ordinarily it would be Miss Shar. She is not present. So, in any event, Mr. Green appears by reliable electronic means from the Cass County Jail without counsel. Mr. Green, can you hear and see me okay?
Yes, sir, Your Honor.
You present in court when I read you your rights in contempt proceedings?
I was not present, but I understand them.
Well, I know you were connected because I saw that you were connected when I read those rights to the last individual, Mr. Tormey.
Okay, yes, yes, sir, Your Honor. Yes.
I read them to all of you appearing on orders to show cause.
Yes, sir.
All right. So you were present when I read those rights.
Yes, sir.
And do you understand your rights, sir?
Yes, sir.
In your case, there was back on April 23, 2026, you were required to appear.
Yes, sir.
So there was a warrant issued on April 14, 2026. You were released on the warrant and signed a promise to appear on April 14. That's record index 25. And you paid $250 to secure your release. And you were given a court date of April 23 on that promise to appear. You were given notice of hearing for an April 23 hearing. On April 23, 2026 at 10 a.m., you did not appear. The court issued a warrant of attachment. And the warrant of attachment requires you to appear at the next order to show cause hearing. And it requires you to pay $500 in bond. So I already have set bond in this matter. The $250 that you posted on April 14 was revoked and forfeit and applied to your child support obligation. And so the only issue that's left for today, sir, is to set your next hearing. Your next hearing will be scheduled for September 10, 2026 at 10 a.m. So your next hearing will be a child support order to show cause on September 10, 2026 at 10 a.m. Mr. Green, do you understand when you need to be in court next?
Yes, sir, and that's Barnes County?
That's in Barnes County.
Sorry, Your Honor.
In the Barnes County Courthouse?
Yep.
Okay, 3rd floor in Valley City. That's where you have court. and when you need to appear again, September 10, 2026, 10 a.m.
Okay.
Do you understand when you next need to be in court?
September 10th at 10,
At
10 p.m. or 10 a.m. Sorry.
if you show up at 10 p.m., it's going to be a pretty dark.
I'm sorry. 10 a.m.
All right. So you know when you next need to be in court. I set your bail as a condition of the warrant. And so what you'll need to secure your release between now and then will be posting that $500 and signing a promise to appear on September 10, 2026.
So, Your Honor, you're saying that I have to stay sitting here in jail? I don't have no way of getting $500 right now. I was hoping that I would be time served and can get out and hopefully get some work or daily pay to save up some money so I can pay.
Well, if you had,
I have nothing. The best I'd be able to do would be some daily pay right now to actually just save up money so I can pay for my next visit with you guys. Because I've been in here since June 12th. So, I mean, I have nothing.
What have you been in there since June 12th for?
It was probation revocation. And I just executed that sentence on the 16th of this month, which would have been this past Sunday. And then I've been held on your guys' warrant since then. So that's why I was going to say, if I could get time served for now, and then I promise to appear September 10th at 10 a.m. and have a payment.
So when the state's attorney, not the county prosecutor, but the attorney representing the state of North Dakota's Child Support Enforcement Division, when she was present in court on the 23rd of April, she requested $500 as a cash bond. That's what I said. And so that's going to stay for now.
I have no way of, so I got to stay in jail till September 10th now?
Well, you can request a bond review, and if you do that, it'll be within 48 hours of right now. But I'm leaving bail as I previously said it for now. If you stay in custody for longer than 2 days' time on the court's order now, and you're not being held for any other reason, you can request a bond review where Miss Shar will be present and she'll have notice to appear. In your case, she didn't have notice, or at least not adequate notice, because I just received notice that you were now sitting on just my case this morning at about 9:30. So I didn't know that your case was going to be called until very shortly before court was called, and I'm certain Miss Shar didn't get notice in time either. So if you sit over the weekend and you still are unable to come up with $500,
yeah, there's going to be no way. I don't have
so
nothing.
Stop talking, and I don't want you to interrupt me. So if you're unable to do that, sir, you can request a bond review, and all parties will be present, and we can talk about your bond again. But for now, that's what I'm going to do. So you'll need to sign a promise to appear and post bond. Those will be the conditions. And again, you can request a bond review by letting the jail know to send a note to the court. And that note will get passed on to the other side, and all parties will be present for that bond review, and we can take it up again then.
Okay.
Any questions, Mr. Green?
No.
All right. With that, that's the court's order. I'll get something in writing put together and sent over to the jail here in the next hour or so the jail understands if there's a jailer sitting with you. All right?
All right.
With that, we're adjourned.
So these cases always baffle me and bother me. I mean, yes, deadbeat parent needs to take care of the child. I get all of that. But we're not supposed to have a debtor's prison here in the United States, but we have that. And that's pretty much a debtor's prison. And the longer he sits, the longer he's in jail, the less likely it is for the custodial parent to get money. So there's that factor. Plus, and I say this every time I have the opportunity, I also have an issue with the fact that no place in the United States is the custodial parent required to account for how they spend the money. So there's no guarantee that this guy's child is actually getting the money either, because the parent isn't required to prove where the money goes. It's a messed up system. At the end of the day, it's just messed up. That having been said, it is that time, my friends. We are at the bottom of the hour. It is time for our Friday Guilty Pleasure, the best, worst court you will ever see. If you are new to the channel, pay attention. We have blood red carpeting. Looks like it was something ripped from The Shining. Cold War Soviet-era lighting hangs from the ceiling above the two desks. The limestone wall in the background, which every now and then, if you look closely, you can see it seeping just a little bit of blood. The screams of the undead from the background. A judge who is not shy to raise his voice, and you know when it happens, because one microphone that picks up everything from 3 counties away. A printer that never stops running. A prosecutor as old as the Crypt Keeper himself. They say, they do, that Appalachian justice is best served in a cold, dank basement. And therefore, my friends, I give you Dungeon Court.
25376. Okay, we've got some more community service to get done. You did finish your counseling, and you have fines to pay. Do you have a payment on your fine today?
No, not today, Your Honor.
Okay. Fines to pay. Do you have a payment on your fine today?
No, not today, Your Honor.
Okay.
Next week, though.
All right. Well, we need to get that work. You did do 1 day community service this past month. You've got 36 more hours to do.
But I'll also be here tomorrow.
I'm sorry?
I'll also be here tomorrow for...
Tomorrow for community service? Okay.
Yes, sir.
Mr. Kuzbro got that down. And you're obviously working.
Yes, sir.
Okay. Please mute your microphone if you're on teleconference. What's best for you, Mondays or Fridays?
Either or, Your Honor.
Okay. I'm going to set it for September 28th. Is your next hearing at 9 o'clock.
Thank you, sir.
All right, Stephen Carmen, 22-2038. Stephen Carmen. Let's check this one. I'm sure he's done everything except 4 hours of community service.
Your Honor, that is correct. He had 10 hours the last time he was here. He was here the following day from court. He said he'd be here the next day, and that I do believe he still has 4 hours.
Okay. All right, so, well, I'm looking on the file. I have it down for August 31st. As his review hearing. So let's pass it till then. I'm going to issue a warrant for him. We got it on the wrong day. So I've got him down for August 31st as his next review. So I'll pass it to August 31st. James DeMint is here. And we've got a report. Okay, so you've got a job lined up with that. I'm okay with that as long as you can continue with your counsel.
Yes.
So you're not going to be, you were doing it yourself as a contractor before, weren't you?
Yes.
Okay, you're not going to work for somebody else now? Or?
Yeah. For a little bit,
to get things straightened out.
Okay. Okay, it's a good report. I agree with you going back to work. I want you to do that. I know you've not worked for a while. Can you pay anything on your fines? Or?
I did last week.
Okay. Yes, it's noted in the file. All right, well, hopefully this time you're going to get it all right. So, good start. Does it matter what day of the week you come back for your next hearing?
It's either or.
Okay. I'll do you for September 28th also. That's a Monday. September 28th, 9 o'clock.
Thank you, Your Honor.
Leave the microphone off.
Thank you.
You're welcome. Miss D. Dotson is here, 23706. She usually has a report for me from Marshall Health.
Yes, he can keep them.
Okay. Can you pay anything on your fines today?
Yes.
How much?
10.
Okay, it's a good report from Marshall. Make your payment. I'm going to set you for October 2nd at your next hearing.
Thank you, Your Honor.
You're welcome. 9 o'clock, October 2nd. Go see the clerk. Timmy Fortner is here. 25301, 25709. Okay, still got some community service to do and fines to pay. And yeah, you did quite a bit this last month.
Thank you.
18 hours. Okay.
Thank you.
Are you paying anything on your fines today?
Next week, sir.
Okay.
Okay.
All right, keep working on your community service like you have been. I'll set you for October 2nd also as your next hearing. 9 o'clock, October 2nd.
Thank you, Your Honor.
You're welcome. Isaac Hall, 2668. Okay, and he's at Bethesda.
Yes, sir.
And that's all you've done everything else?
Yes, sir.
Fines are paid, community service done?
Yes, sir.
And we got a report from Bethesda. And how often are you going for sessions now?
I'm still doing the two a week.
2 a week? Okay. All right, well, let's continue with that, but I'm not going to make you come back for a review hearing. We'll go maybe 6 weeks out or so, since you've done so well. So let's do it, does it matter if it's Mondays or Fridays?
Fridays.
Fridays are better. The 23rd of October, so 2 months really. October 23rd will be your next hearing, 9 o'clock. We may finish things up then.
Okay.
Thank you, Your Honor.
Thank you, sir.
You're welcome.
Jordan Wolf, Jonathan Carr, Shane Lyons, Angel Martin, Sean Miller, Jason Packard.
All right, Jordan Wolf is here, 25-123. Okay. For me. From OVP. report your screens are good and you're compliant with your program. Okay, can you pay anything on your fines today?
Yeah, I tried to pay some this morning online, but it wouldn't work for some reason, so I'm gonna try again this afternoon.
Can you pay here?
Yeah, I can pay here.
Okay, just go, how much are you gonna pay?
25.
All right, go see the clerk, make your payment.
Your Honor, she was at community services also.
Okay. Fridays or Mondays, or does it matter?
It doesn't matter.
Okay, I'm gonna set October 9th. October 9th.
Thank you.
You're welcome. Jonathan Hart, 16,926. Jonathan Hart is not here. And he's got a lot left to do, so there'll be a warrant failure here. Shane Lyons is here.
Yes, sir.
10/9/29, 10/20/70, 19/181, 19/12/35. There's still community service left on these. Yeah. All right, so are you paying anything on your fine today?
Yes, sir.
How much?
35.
All right, I need a commitment when you're going to come out. Give me a date when you're going to be here for community service.
I work full-time. I didn't know I had community service.
Well, that's what I'm showing back. This is a long time ago, but it was a case from back in 2010, and it's never been done.
Ain't no way I could just pay it in fines.
No, you have to do it.
Okay.
You got to suspend the jail sentence.
All right.
It was a felony drug abuse charge that was reduced to a misdemeanor attempted drug abuse, and you got a 15-day jail sentence, which you'd already served, it looks like, in 90 days, 75 days suspended, credit for the 15 days, and then 30 hours community service.
How many hours? 30 hours?
Yeah, so that's
Okay.
5 days.
Okay. Can I do it on Fridays?
Yes, sir.
Fridays would be good.
Okay. So you'll be here next Friday for community service.
That'll work.
Report here, Mr. Cooper, you want to talk to him about it, or?
I will, Your Honor.
Okay. Talk to Mr. Cooper about it. So Fridays are best for your reviews then, too?
Yes.
Okay. These are old cases, so we need to get them done.
All right.
I'm going to set up for September 25th.
Okay.
Next hearing, that's the last Friday of September.
All righty.
See Mr. Cooper, then you're free to go. 9 o'clock, September 25th.
All right. Appreciate it.
And see.
So for those of you who are new to the channel, do take a moment, go to the pinned chat, and there's a link to our official Dungeon Court brochure. You will want to take a look at that because, number one, it explains a lot, but number two, it's hilarious. So check that out.
You just have to pay off your fines, and you've been making payments. Do you have a payment today?
Yes.
How much?
50.
Okay. Go see the clerk to make that payment, and I'll set you. October 2nd. If you pay it off, you don't have to be here. Go see the clerk.
October what? I'm sorry.
2nd to October 2nd.
Okay. Thank you.
You're welcome. Sean Allen.
While we're waiting for the next contestant to come up, Alita just gave us $20 over at courtroomfiles.com. Thank you so much for that. I very much appreciate that. Thank you.
Is not here, and he has things left to accomplish, so he gets a warrant for not appearing. Jason Tackett is here. You have fines to pay. You have a payment today.
Yes, I'm gonna pay 100.
Okay. Do you prefer Fridays as your hearing days?
Yes, that's fine.
October 2nd will be your next hearing. Go see the clerk to make your payment today.
Thank you, Your Honor.
You're welcome. I think that finishes the reviews, does it not? So next, we're going to do the arraignments, which are new cases or old cases where you missed a hearing. They'll get called with the arraignments. So let's wait till we get everybody in. When your name's called, come up to the table to your right, stand there. I'm going to go over the charge with you. The charge is decided by the prosecutor. It's not my job to decide what your charge is. So it could be, I don't know anything about these cases usually. I just read what's in the file. So it could be totally made up false, but you have to understand what you're charged with. So that's what I'm going to tell you. This is what they're charging you with. You have a right to remain silent. You don't have to say anything, but what you're saying in open court is not privileged. In other words, that means, and I have people do this all the time, they get up and start running off at the mouth, telling me, well, this happened, A, B, C, D happened, I shouldn't be here because I did this. Well, you're stuck with what you say because admissions are a big deal in the law. So once you get up and start talking, you're stuck with what you say. What you tell a lawyer in private is privileged, but what you say in the open courtroom is not privileged. And today's not the trial. So it doesn't do any good to come up and tell me I shouldn't be here because X, Y, and Z. Have a seat, ma'am. Ma'am, I am talking.
Sorry.
Do not get up while I'm talking and leave and walk out. So, it's in your interest, if you want to talk about the case, to wait and tell it to a lawyer, not tell it to me in the courtroom. You have a right to bail. You have a right to make the state of Ohio prove the charges beyond a reasonable doubt. That's the highest proof in the law. If you enter a guilty plea or no contest plea, you're waiving all those rights I just explained to you. You should not do that. If you're not absolutely sure that's the plea you want to enter, because I have people say all the time, I just want to get it over with. That's not a good reason to enter a guilty plea. So if you're not sure what to do, not guilty is always the best option. You can change your plea later, but once you've pled guilty, it's hard to withdraw. So don't do that just as convenience, because all the cases here are jailable. Call the first case.
State of Ohio versus Nunez and Atalio. Nunez and Atalio, case number TRD 261425, A and B.
All right, so this is for arraignment on what I just said. All the cases here are jailable. This got filed in the wrong court. This should have been filed in traffic court, which is for non-jailable traffic offenses. So, as my understanding, Mr. Anatolo does not speak English very well, and you're here kind of as an interpreter for him.
Yes.
He's getting a lucky break today. I'm going to dismiss his case. I don't know, he was charged with not having a license and running a red light. So he should have been sent to traffic court, not to the criminal court. So the only way the police officers learn to follow the right court is if I dismiss it. So it doesn't mean that he doesn't need a driver's license or that he shouldn't stop at red lights. It just means that it's a technicality. And for that reason, I'm dismissing his case. He's free to go.
Thank you, sir.
You're welcome.
State of Ohio versus Jacob Blackwelder, case number CRB 26509. Mr. DeWater.
All right, we need Mr. DeWater in the courtroom. This is Mr. DeWater's case. He hasn't been arraigned, has he?
No, Your Honor, this is just an arraignment today.
So,
We'd waive
read the charges, you waive that?
No, we'd waive a reading of the charges and waive any defect in the time, manner of service, and enter not guilty plea.
A not guilty plea is entered. What about bond? He has posted a bond, so Bond will be continued. Is there a protection order requested here?
Yes, Your Honor.
Any problem with him staying away from the complaint party?
No.
Okay, so you understand that, sir? Your word to stay away. And here's the other thing I would add to it, just the goal of the protection order is that there not be an allegation that something else happens while we're pending for court. So nowadays, I have to tell people, don't post stuff about this on social media. Don't text the person. Don't contact them by any sort of social media at all. So just let things die down. Okay, so the protection order is for Morgan Workman. So your order does not go around or contact that person.
Yeah, the only thing, just let me look at this protection order real quick to make sure the address is, well, there's no, it's not filled in. Just for purposes of the record, the two of them were living together, and they're not anymore. Morgan has moved out of Mr. Blackwater's house.
Okay.
So I just didn't want the protection order to suggest that he wasn't supposed to go to his own home, and it's not filled in yet, so
All right.
I'll leave that for the prosecutor's office to fill in.
All right, so just for, you can't go around her. Anything else?
The other thing I discussed with Mr. Hill this morning was Mr. Blackwater gave his phone to the sheriff's department.
You need an order for that, prepare one.
I've got one. Mr. Hill wants me to check with the sheriff's department to make sure they're done with it. And so as soon as I confirm that, I'll bring the order back to you.
All right, what about a follow-up hearing date when you want to come back for a pre-trial?
Do you have one on the 21st of September? I've got 2 other hearings that day.
That's fine.
Okay.
September 21st will be the pre-trial, and it'll be at 10 a.m.
Thank you.
You're welcome.
State of Ohio versus Brian Pennington, case number TRC 261421, A and B.
Sir, are you Brian Adam Pennington?
Yes, sir.
Mr. Pennington states alleging that on August the 15th of this year at 2:49 a.m. in Fayette Township, you were driving a vehicle while you were under the influence of either alcohol, drugs, or some combination of those substances, and that you refused to take any tests. The state's also alleging that you've got 2 prior convictions within the look-back period, so that would make this a 3rd offense. And let the legislature in the last few months changed the law on this and not the penalty, so I've got to get my cheat sheet to look and see what they've done, especially on a 3rd offense. On a 3rd offense with a refusal, the minimum penalty now is 60 days in jail. Well, let's go with the maximum. The maximum is 1 year in jail, $2,750 fine, and a 12-year license suspension. And also, if the vehicle was titled to you, it's required to be forfeited on a 3rd offense to the state. The minimum penalty on a refusal 3rd offense is 60 days in jail, a $1,040 fine, and a 2-year driving license suspension. And, as I said, the forfeiture of the vehicle. You're also charged with driving while your license was suspended from the prior OVI conviction. That's a 1st-degree misdemeanor. Carries a maximum penalty of 6 months in jail and a $1,000 fine. There is a minimum penalty on that as well, and there's a mandatory 3 days in jail, $250 fine on that charge. Do you understand these charges?
Yes.
Do you understand the rights I explained defendants have?
Yep.
How do you wish to plead to these charges?
Not guilty.
Do you want a lawyer appointed to represent you?
Yes, please.
Are you working?
Yeah.
What do you do?
Dietary aid at a nursing home.
Are you paid by the hour?
Yeah.
How much per hour?
15.
Do you have dependents?
Yeah, I got 3 kids.
Okay, you're eligible then. I'll appoint Mr. Davenport to represent you. Did you post any kind of bond?
No.
Okay, I'm going to let you sign a signature bond of $3,000. So as long as you come to court, you don't have to post the money. If you fail to show up, you get a warrant, and then you have to pay the $3,000 when you're arrested.
Okay.
So let's see about pretrial dates.
Is the 28th available?
Of August?
Of September. Or is that too far out?
That's okay, as long as there's a time limit.
Yes.
All right, September 28th will be the next hearing at defendant's request. Not guilty plea is entered.
Beg pardon?
Not guilty plea is entered. He will need to go to the jail to get fingerprinted. Did you get fingerprinted before, sir?
No.
Okay. The bail's going to bring you a form you have to take to the jail. Ring the bell. Do that before your next hearing, which is September 28th at 10 o'clock.
Is Tom waiver in writing necessary or?
Yeah, Mr. Hill has one.
Okay.
That he'll fill out.
State of Ohio versus Bradley D. King, case number CRP 26462.
And sir, you Bradley D. King.
Yes, sir.
All right, Mr. King states alleging that at Union Township, July 27th of this year, you knowingly caused Lisa Dillon to believe you would cause serious physical harm to her person or property. That's aggravated menacing. It's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine.
Not guilty.
Do you have money to hire a lawyer?
No.
Are you working?
No, sir.
All right, Mr. Stratton, I'll appoint you. Yes, sir. Protection order requested on this?
Yes, Your Honor.
Menacing?
Is that, do you live with them?
Yeah.
I believe, wait, just 1 second.
Any problem staying away from Lisa Dillon?
I believe,
yeah.
I believe she's.
I did not.
Okay, come up and talk to the prosecutor, ma'am.
Yeah. I'll do the talking. Okay. You don't want a protection order?
No. We were going.
Did you post the bond?
No,
I never heard of it.
Okay,
you're signing.
I didn't send the attachment, everything that was requested. I would like it to be dropped.
I have a signature bond.
So, Your Honor, Ms. Dillon has expressed that she doesn't even want the charges to be filed at this time. They got filed somehow. There must have been something that happened. What we would see.
It looks like there was a fire or something. The fire department was involved. From
But
what
there
I
wasn't.
just glanced at the affidavit, that's what it seems to say.
What we would suggest at this time is if Mr. King wanted to waive his time constraints, we would continue the case for 90 days, and if there were no further problems between the parties, we would dismiss the charges at that time with the payment of court costs.
Yeah, that sounds reasonable, Your Honor.
Okay, so no protection order at her request. We'll go out 90 days as long as there's no further problems, it could be dismissed then with or without cause.
With costs, Your Honor.
Is that agreeable?
With calls. Yeah, that's fine, Your Honor.
Okay. So that's November 20th?
November 20th. Sounds good.
November 20th will be the next hearing. Not guilty plea is entered, he can sign $1,000 OR bond.
He signed, Your Honor. November 20th. Thank you.
You're welcome. Not going to make it. I'm going to dismiss it.
State of Ohio versus Aaron J. Jones, case number TRC 261420.
Okay, you're Aaron J. Jones?
Yes, sir.
Mr. Jones states alleging on August the 14th at 4:44 a.m. in Union Township, you were operating a vehicle while being under the influence of alcohol, and that you states alleging you did take a breath test and tested allowed on the breath test. That's over what's called the per se level under Ohio law. The per se level under Ohio law is 8. So what does that mean? Well, that means that if the state can show a test score on a breath test above 8, and big if, and they can show compliance with the rules for giving that test, they get a presumption that you're impaired due to the test score being above 8. And they're saying you tested 11. They're also saying you've got a prior conviction for some sort of driving offense involving substances in year 2024, which is within the look-back period. So this would be considered a second offense. So on a second offense, the maximum penalty is 6 months in jail, $1,625 fine, a 7-year license suspension, and the vehicle, if it's titled to you, is required to be immobilized for a period of 6 weeks, 45 days. There is a minimum penalty on a second offense with your test score. It's 10 days in jail, $715 fine, and a 1-year license suspension. So that's your only charge. Do you understand?
Yes, sir.
The charge you're facing? Do you understand the rights you have as a defendant?
Yes, sir.
How do you plead to this charge?
I like to plead not guilty, sir.
Do you have, you request a court-appointed lawyer?
Yes, sir.
Are you working?
Yes, sir.
What do you do?
I'm a laborer
Where?
for wall systems.
Are you paid by the hour there?
Yes, sir.
How much per hour?
$14 an hour.
How many hours a week do you work?
Between 30 and 35.
Okay. Do you have any dependents?
No, sir.
Okay, you're still eligible and meet the financial guidelines for court-appointed lawyer. So I'll appoint Mr. Smith to represent you. There had been a capias issued for his arrest for not appearing on the 17th. So I don't know if we let the OSP know that, but they would have been notified of the capias. He has appeared now, so I'll withdraw. He can sign a signature bond of $1,500. And as far as pretrial dates,
Don't leave the lady copy this out of lobby and tell you what you need to do. Go back to your thing. Where's it? My sleeve.
the 18th of September, that's how long your...
But if it's on the list, Judge, it's fine, yes, sir.
Okay.
And I would ask, I kind of heard before I got appointed that his truck is subject to impound. Would it be possible to have OSP put a club on it and have it towed to his residence at his expense?
Yes, if you want to prepare it.
I'll prepare it, yes, because it's racking up impound fees every day.
September the 18th at 10 o'clock.
Yes, Judge, thank you. I'll see him. get in next week.
Okay, do I keep this with you?
Get your, no, that's right, Jay, mine. But you got the next hearing written down, the 18th, at 10 o'clock.
He will need to get fingerprinted.
Yes.
So
You'll need to stand in the lobby, they'll go bring the machine.
they'll bring you
to
the
the jail.
forms to take to the jail.
Get your fingerprints.
Yes, fingerprinted.
You call me in my office.
Okay.
All right.
State of Ohio versus Colin Cofer, case number CRB 26186.
This was Mr. Smith's case.
Yes, sir, yes.
He was set for the 17th. I'll show you he was not here then. So you want to talk and then,
Yeah, if we could.
Recall.
We have a piece of paper, we can recall it.
yeah, we call this later,
I'll
Doc.
see you in the lobby in a second. All right. Yeah, just sit down, I'll be right back.
State of Ohio versus Patricia L. Cook, case number CRB 267. Bring it to appear for review. Patricia Cook. Patricia Cook.
She might have went to the bathroom. It was a little beside me. I'm not sure, but.
Oh, is this Patricia?
Yeah, there you go,
All right.
yeah, sorry.
All right, it's alleged that you had a review on August 14th that you weren't here for.
Yes, sir.
It's on a theft offense. I'm not showing you've done anything on it.
Well, I'm going to pay some of my fine today. I haven't had a vehicle for the last 3 months. I just got it back earlier this week. I had to get a transmission put in it. But I can start doing my community service next week.
How much can you pay on your fine?
100. I'm going to pay 100 today.
Okay. All right, I'll withdraw the warrant. You'll go see the clerk and make your payment. You need to get out here and get your community service done.
Absolutely.
And I will set you October the 5th.
Okay.
It'll be your next review hearing. That's the first Monday.
Okay, I'll have everything
Write
done.
that down.
I'll have everything done by the time I.
Okay, write it down just in case.
Okay.
And for everybody, if you forget something or lose a paper, or don't know what to need to do, if you've got a smartphone, you can look up the website for the court and your case is in there. Do a record search, put your name in, it's going to show up, tell you what you need to do. Or the old-fashioned way, you can actually call the court and the clerks will answer the phone and they will tell you. So I get people all the time, I lost my paper so I didn't know what to do and I got arrested. There's no excuse for not knowing when you're supposed to be in court. Okay, October 5th is your next hearing, 9 o'clock, see the clerk to make your payment.
So if I have the community service done,
You have everything done, you don't have to
Okay.
show up. These are hearings to make sure you do what you're supposed to do. Once you're done, you don't have to come to the hearings anymore.
All right, thank you.
You're welcome.
State of Ohio versus Damien Totten, case number CRN 2651.
Sir, you, Damien Totten?
Yes, sir.
Bail's giving you a copy of the charge. It alleges that at Rome Township on January 7th of this year, he purposely deprived Jamie Blankenship of a Nissan Altima vehicle without the right to do so. So you've been charged with a felony for theft offense. Maximum penalty is 18 months in jail, $5,000 fine. Do you understand this charge?
Yes, sir.
Do you understand the rights you have as a defendant?
Yes, sir.
Do you need a lawyer appointed to represent you?
Yes, sir.
Do you have a job?
No, sir.
You have no income?
Not at the moment. Not with the warrant out.
What's your current address? I don't have an address for you.
123 Rice Street, RICE, Beckley, West Virginia, 25801.
What was the zip again?
25801.
I'll appoint Mr. Steyer to represent you. Did you get served by mail or how did you know to be here today?
I don't know to be here today. I got arrested and like 4 hours away, and was held for 30 days, and then just now was able to get here and get put on block.
Did you post a bond somewhere, or how did you get out of it?
Nobody came and got me. They didn't extradite me.
Oh, okay. All right, so I'm gonna let you sign a signature bond then, since you showed up on your own. You can sign a $2,500 OR bond. Do you want to come back within 15 days or waive it since he's from Beckley? You want to talk about that, see when you want to come back?
Normally they have 15 days to have a preliminary hearing, but if you're coming up with that, we can go out a little further to give you more time. It doesn't really hurt you in this situation, I don't think.
I can do the 15 days. I just need to get the out the way so I can get back to work. I can come back in 15 days.
Is this stopping you from working, is what you're saying?
Yeah.
Okay, this is actually stopping him from working, Your Honor, so we'd like to stick within the 15 days if we could, Your Honor.
All right, so that would be,
I am not here Monday, but I'm here. I'm sorry, I'm here the 28th and the 31st, if one of those days would work.
looks like the 28th. Next Friday is probably the best. So set it for then.
If we could, Your Honor, please.
August 28th would be the next one for a preliminary hearing at 10 o'clock.
Thank you. Anything else at this time? All right.
I'm not going to, at this point, I may later make a fingerprint.
Okay. All right.
State of Ohio versus Chantel Wilson. Case number CRA 24154. Chantel Wilson.
Okay, so she's at Southern Hope. Through Cabot County, so apparently there's something going on over there too. This is a theft offense. That's an older case, but it's from March 7th of 2024. Were you here when I explained the rights of defendants? Do you understand that? Do you have any questions? No? This charge alleges that at Perry Township here in Lawrence County on March 7, 2024, he purposely tried to deprive Ashley Webb of property, being a debit card, and that apparently it was used for a charge of $282 that was not authorized by you. That's a felony 5, carries a maximum penalty of a year in jail, $2,500 fine. Do you understand this charge? You have made out a lawyer? Are you inpatient at Soda? Okay.
That's the movie I just did.
So we're back to Mr. Stratton. I'll appoint you. So represent Ms. Wilson. State's position on bond for Ms. Wilson.
We're not opposed to an OR bond, but we'd like it conditioned on her remaining in treatment.
No issue there, Your Honor.
All right, I'm going to let you sign a signature bond of $2,000 with a further condition that you remain in treatment at Southern Hope and that you take it seriously. I just looked at your report.
Yeah, I'm working on it. I have that attitude problem. I'm sorry.
Okay, good. For this court, and you got something going on in Cabell County, I know enough to say that when you get a report that says Client has been put on a behavioral contract for being disrespectful to staff. Client has no motivation. Client is never wanting to comply with services. That's not the kind of report you want to go into court with. I mean, it doesn't take a brain surgeon to figure that out. I don't know which judge you're in front of over in Cabell County, but it's not going to work in this court.
I haven't went in front of one over there. I'm on 2 years probation right now.
Okay. Well, I think the way that works over there, I am admitted in West Virginia, so I know a little bit about it. If your probation officer sees this, he can jerk you in front of the judge.
I see him again the end of this month.
Okay. Well, I would, if it was me and I was in your place, I'd want a lot better report going to my probation officer before I went over there. So I try to adjust my attitude.
I'm working on it, I'm sorry.
Okay. Because I have had, and I'm not going to go over and beg anybody to keep you out of penitentiary. Like, I have done that before. I don't know to say I'd regret it, but I'm not going to do it for you. I don't know you that well. But I had somebody here that was doing really well in treatment, and Judge Ferguson sentenced to 1 to 10 over there, so I had to go kind of beg the judge not to send him away to the pen, which he did for me. But I'm not going to do that for you. I don't know you that well. Okay? So you're on your own. Get good reports for this court and the court over in Cabell County. It's not that hard to do. When you're thinking of acting out, think, do I really want to say this or do I want to go to prison? No, I don't want to go to prison, so I'm going to be on my best behavior. Okay. When do we want to come back? Do you want to waive time constraints?
We'll waive time, Your Honor.
Okay. Let's do September 4th.
September 4th, okay.
Can you get her to the jail to get fingerprinted?
Yes, we can.
Okay, she will.
Okay, all right.
Southern Hope will take her down there. So you probably have people going down to the main courthouse anyway, don't you?
Wait, 1 second.
Yes, sir.
All right, you got to get fingerprinted at the jail.
Okay.
Be back here September 4th with a good report.
All right, thank you, Your Honor.
Alrighty, friends, that will do it for TCF Live for today. Lindsay and Wahoo, thank you for your sponsorship of that extra little bit of overtime for us to watch Dungeon Court. I appreciate that. So we'll be back Monday morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member. But fear not, this channel has, 2,500 or something like that? Different videos available to you, from live streams to standalone cases to shorts to you name it. So there's lots for you to watch this weekend. So browse the channel and we'll be back live on Monday. Until then, go have yourselves a glorious weekend, and thank you all so much for spending your time with me. Take care. God bless.